การกินเค็มหรือการบริโภคอาหารเค็มเป็นปัจจัยสำคัญที่ทำให้เราป่วยเป็นโรคไตและก็โรคอื่นๆได้วันนี้ค่ะเรามีเทคนิคและวิธีการในการลดความเค็มในอาหารอย่างง่ายๆจากคุณหมอผู้เชี่ยวชาญมาฝากกันค่ะ
คนไทยกินเค็มกว่าความต้องการ2 เท่านะครับแล้วก็ความเค็มทำให้เกิดความดันโลหิตสูงซึ่งจะนำไปสู่โรคหัวใจโรคอัมพฤกษ์อัมพาตแล้วก็โรคไตนะครับซึ่งการล้างไตหรือว่าการฟอกเลือดด้วยเครื่องไตเทียมนั้นก็ทำให้ผู้ป่วยได้รับความทุกข์ทรมานแล้วก็เสียค่าใช้จ่ายจำนวนมากนะครับปัจจุบันมีคนไข้โรคไตโรคความดันโรคหัวใจเนี่ยทั่วประเทศอย่างน้อย20 ล้านคนการกินเค็มต่อเนื่องทำให้เกิดโรคที่ไม่ติดต่อเหล่านี้นะครับไม่ว่าจะเกิดความดันโลหิตสูงนะครับแล้วก็ทำให้เกิดอาการบวมแล้วก็นำไปสู่ไตวายเพราะฉะนั้นการที่เราจะลดความเค็มลงก็จะสามารถทำให้เราห่างไกลจากโรคต่างๆเหล่านี้คนที่ยังไม่เป็นโรคก็สามารถป้องกันไว้ก่อนนะครับคนที่เป็นโรคแล้วก็สามารถชะลอไม่ให้ไตเสื่อมหรือไตวายมากขึ้นการที่เราจะสามารถลดการบริโภคเค็มได้เนี่ยก็ต้องค่อยๆทำนะครับเพราะว่าการลดทีละน้อยไม่เกิน 10% ลิ้นเราจะจับไม่ได้ลดทีละน้อยทำให้เราคุ้นชินกับรสชาติที่อ่อนลงนะครับอีก 2-4 อาทิตย์เราค่อยๆลดอีก 10% ภายในระยะเวลา3 เดือนสามารถลดลงได้ถึง 30% โดยที่ยังมีความสุขกับการกินเหมือนเดิมนะครับหลีกเลี่ยงอาหารที่มีความเค็มสูงอย่างเช่นอาหารที่แปรรูปนะครับไส้กรอกแฮมเบคอนหมูยอแหนมกุนเชียงโดยเฉพาะเครื่องปรุงรสบนโต๊ะอาหารเนี่ยควรจะหลีกเลี่ยงนะครับเพราะว่าในครัวเขาเติมเครื่องปรุงรสมาเพียงพอแล้วอีกอันหนึ่งที่จะต้องพยายามลดการบริโภคก็คือเรื่องของน้ำซุปนะครับเพราะว่าในน้ำซุปเนี่ยจะมีเกลือมากไม่ว่าจะเป็นผงชูรสซอสปรุงรสต่างๆหรือว่าซุปก้อนนะครับรวมทั้งซีอิ๊วน้ำปลาต่างๆอันนี้ก็จะเป็นแหล่งของโซเดียมถึง 50% ของชามนั้นถ้าเรากินก๋วยเตี๋ยวทานเส้นทานผักทานเนื้อแล้วก็ทานน้ำซุปน้อยๆเนี่ยก็สามารถลดปริมาณเกลืออย่างน้อยถึง 50%โรคไตเนี่ยนอกจากการที่เราจะกินเค็มแล้วก็ต้องระวังเรื่องน้ำหนักตัวด้วยเพราะถ้าเรากินเค็มแล้วเรามักจะกินหวานเพราะว่ากินเค็มกินหวานจะทำให้รสชาติกลมกล่อมนะครับก็ทำให้น้ำหนักตัวขึ้นพอน้ำหนักตัวขึ้นความดันก็จะสูงนะครับบางคนก็ไม่ออกกำลังกายนะครับอันนี้ก็ต้องหลีกเลี่ยงนิดนึงเพราะว่าการออกกำลังกายจะทำให้ร่างกายแข็งแรงแล้วก็ลดน้ำหนักนะครับไม่สูบบุหรี่ไม่ดื่มเหล้านะครับหลีกเลี่ยงของหมักดองนะครับอันนี้ก็จะทำให้ห่างไกลจากไตวายโรคหัวใจโรคมะเร็งต่างๆได้ด้วยนะครับ
เริ่มจากลดเค็มลงทีละนิดเพียงแค่นี้เราก็สามารถเปลี่ยนวิธีการรับประทานอาหารไม่ให้เสี่ยงต่อการเกิดเป็นโรคไตได้แล้วค่ะและนี่ก็คือความรักและความห่วงใยจากมูลนิธิโรคไตแห่งประเทศไทย40 ปีแห่งการให้เพื่อผู้ป่วยโรคไต
It is time for the last match to commence. This match will be between the English teams, Onni และผู้ติดตาม and Undertake. Onni และผู้ติดตาม will represent the plaintiff's lawyer, while Undertake will represent the defendant's lawyer. Ladies and gentlemen, please give the big round of applause for Onni และผู้ติดตาม and Undertake. Thank you. The case presented in the final round today is a dispute over patent and trade secrets issues. This case is presented in a hypothetical court of Galen, a country which has been swarmed by a deadly disease called equatorial acute respiratory syndrome or EAS. For their survival, the people of Galen need medicine, the processes of manufacture of which are patented by Cipher, a foreign company of insomnia, a country with immense technological advancement. The case revolves around the issue of compulsory licensing order by the government of Galen. The order compelled Cipher to hand over the claims of its patent, namely a patent for medicine targeted at curing AIDS disease, for government use. In order to provide access to its medication for the people of Galen at an affordable price. However, such action was not without cost. Cipher's incentive to invent new drugs were compromised and it decided to bring a case to the Court of Intangible Property of Galen against the Prime Minister of Galen, so as to argue for the illegality of the issued order. The court has settled the disputed issues as follows. 1. Is the compulsory licensing order in question issued during a state of war or emergency as required by the law? 2. Is the compulsory licensing order in question necessary for the purpose of national defense or maintaining national security? 3. Does the compensation offered by Galen constitute a fair remuneration under the law? 4. Is the order compelling Cipher to reveal the trade secrets lawful? I would like to welcome the Committee of Judges who will preside over this case. The Committee of 5 consists of the Honorable Vichai Ariyanantaka, former Senior Judge of the Central Intellectual Property and International Trade Court. The Honorable Suthatip Yuttayotin, Vice Presiding Judge of the Central Intellectual Property and International Trade Court. The Honorable Warawong Acharawongchai, Vice Presiding Judge of the Central Intellectual Property and International Trade Court. Mrs. Pachima Thanasanti, Associate Judge of the Central Intellectual Property and International Trade Court. Mr. Visan Wanasaksi Sakun, Associate Judge of the Central Intellectual Property and International Trade Court. At this moment, both teams are in position and are now ready to begin. The 2023 CIPITC Moot Court Competition, English version shall start now.
So we have come to the conclusion of a very, very important moot court competition in Thailand, and this has been organized for almost the second decade by the Central Intellectual Property and International Trade Court. This is a biennial event of moot competition specializing in intellectual property disputes. And maybe this is the finest training of the legal profession, of which we are very proud of. We mean Central Intellectual Property and International Trade Court, because we help train the future generation of our legal profession to deal with cases of international importance, not only in our court system, but maybe you are required to serve your client in elsewhere, the High Court of London, the Southern District of New York, or the High Court of Singapore, or Hong Kong, or international arbitration. That is something that you have to serve the legal community and the legal need in Thai trade industry, and we welcome back all the law schools here. All of you are winners by the very fact that you participate in this competition. You may have a look at the problem, and like everything else in life, you may get a hard question, a hard task, or a soft task, a softer task. It doesn't mean that you are at an advantage or disadvantage. Even though you've got a harder case to defend or to argue, maybe it needs more of your competence in order to defend, in order to protect the best interests that the law, in the ambit that the law allows for your client. So this will show your competence in doing just that. And today, this court is more like an administrative court, because the defendant is none other than the newly elected Prime Minister of Garland. Yes, yes. And the government of Garland is the defendant, and the representatives of the defendants are some of the best people in the Attorney General office. And obviously, CIPITC has retained some of the, if not the best, but perhaps the most expensive lawyers that Garland can provide. So we'll see how they are doing. Okay, so we will start with the claimants. You all have divided among yourselves of what of the allocation of time that you will be conducting your case, oral argument, and then we have the defendants. So if you are ready, then the first counsel for the plaintiff, please take your stand.
Mr. Chief Justice, Your Honors, and may it please the court. My name is Norwish Limpangon on behalf of the plaintiff. I will be addressing the preliminary matter, the issue of the state of war or the state of emergency, and whether the act is necessary for the purpose of the national defense and the maintenance of the national security. My co-counsel, Panturapon Donskun, will address the issue of unfair remuneration fee and the unlawfulness of the order to disclose the plaintiff's trade secrets. And we have 10 minutes for rebuttal and conclusions. Your Honors, in these preliminary submissions, the plaintiff would like to establish the ground for arguments and submit that the court have jurisdictions over all the claims. And before we start, the plaintiff would like to bring up the fact that Garland and Thailand has the same substantive and procedural law, and that is why Thai law and jurisprudence can be relied upon. And before we dive deep into any submission, Your Honors, the plaintiff would like to establish that there are two provisions under the Patent Act that relate to this situation, which is the compulsory license the government used in questions. The first provision is Section 51 of the Patent Act, where the right is exercised by the ministry, bureau, or the government department. And the second provision is Section 52 of the Patent Act, where the order was given by the Prime Minister along with the approval of the Cabinet. Your Honors, may I draw your attention to paragraph 11 of the agreed fact. The newly elected Prime Minister or the defendant, after general election, issued the right under the patent of the plaintiff to be exercised, along with the approval of Garland's Cabinet, and therefore the plaintiff would like to affirm that this dispute is on the basis of Section 52 of the Patent Act only. The appeal on the order and the amount of remuneration therefore was done under the virtue of Section 52 and thus in this court jurisdiction. For the issue of the trade secrets, the order is to have the plaintiff disclose know-how of the manufacturing process to the OMID. And if that know-how was submitted to OMID, OMID will be considered the state agency responsible for the maintenance of the trade secrets. but under paragraph 12 of the agreed fact, Your Honor. The policy underlying this order is to have OMID disclose this know-how to Biogarland Company Limited. And therefore, the dispute to be considered is whether this act fall into Section 7, subsection 2 of the Trade Secrets Act or not. Since the plaintiff will submit that the act does not fall into any exception, the objection of the plaintiff, therefore, in this case, is considered since the threat is imminent and the infringement is imminent and the order is unlawful as an injunction for the permanent stop infringement of the trade secrets under Section 8, and therefore, in this court jurisdiction, pursuant to Section 14 of the Trade Secrets Act. Your Honors, the compulsory license under Section 52 consists of two initial elements. The first element is that the situation must be state of war or the state of emergency. And the second condition is that the act must be necessary for the purpose of national defense and maintaining national security. For the first submission, Your Honor, the plaintiff will establish that the situation in question at the time of compulsory license is neither the state of war nor the state of emergency. Since the term state of emergency is undefined under the Patent Act, Your Honors, Article 31 of the TRIPS, along with the Doha Declarations, together shall be used to interpret the terms in advantages of justice, compliance with Regulation number 33 of international trade, of the intellectual property and international trade cases. Your Honors, under Article 31I of the TRIPS Agreement, when the law of the state allow the use without authorization on the subject matter of the patent, including the government use, the legal validity of the decision shall be subject to the judicial review, and that the flexibilities of the aforementioned provision was recognized by Doha Declaration such that the state can grant the compulsory license and have the freedom to determine the ground of granting it. Also, the states are free to determine what constitutes the national emergency, providing that the public health crisis can be considered as one of those. Your Honors, this can be interpreted that the state have freedom to determine the ground, and Garland in this case has chosen the state of emergency as one of the ground to granting the compulsory license. And when the state have freedom to determine what constitutes national emergency, it is a must to interpret what emergency is from the domestic law, which in this case Thai law shall be applied. With this link, Your Honor, the closest law to interpret whether or not the situation is emergency or not is the Emergency Decree on Public Administration in Emergency Situation BE 2548. Under Section 4 of this decree, in order for the situation to be considered emergency, there must be a necessity to enact emergency measures for the aversion or remedy of the public calamity or the public disaster, and that public disaster must be in the manner that is urgent and serious. However, in this case, Your Honors, there is no necessity to enact the emergency measures from the first place. May I draw your attention to paragraph 8 of the agreed fact, please, Your Honor. In the first 6 months, 10% of the whole population were infected, which means that 5 million people were infected. The fatality rate is 5%, which means 250,000 deaths occurred in that 6 months at a time. Your Honors may think that this already considered an emergency, but unfortunately, the government of the defendant did not agree so. Your Honor, the only measure that was taken by the government is not declare the state of emergency or the emergency measure, but simply recommend the use of face masks. The recommendation that has no any legal effects, Your Honor. The restaurant and the market are all allowed to operate normally. And with so recommendation, is very surprised, Your Honor, that the fatality rate was reduced to only 50,000 deaths per year, which means 25,000 deaths per 6 months, or it is 10 times lower than before. Your Honors, if the situation in the past, which is 10 times more severe, is not considered necessary to enact the emergency measure, the current situation that is 10 times lighter shall not be considered that such kind of emergency measure shall be enacted. Although there's the margin of appreciation for the state to determine what constitutes the emergency, there's no room for the state to abuse its own discretion. Your Honors, the defendant may argue further that there might be some necessity to enact emergency measure, but the plaintiff believes that the conditions still not satisfied, since the public disaster is not in the manner that is urgent and serious. The reason is that urgence requires an immediate action. And serious in this case can be examined in the number in terms of quantity. But according to the fact, Your Honors, the situation at the emergent points never be considered as urgent or serious situation, since there never be any immediate action taken by the government. And also, if the Honors look in the fact, we can see that the number of the fatality and inferable that the number of the infectious is lower than before. And therefore, at the time of the compulsory license was ordered, the situation is not anymore considered emergency since the public disaster is not urgent and serious. Moving to the second point of the submission, Your Honors. The meaning of the state of war also is undefined in this act. And therefore, the Hague Convention 3 shall be used to interpret the occurrence of the state of war. Your Honors, under Article 1 of the Convention, hostility shall not be commenced unless with the declaration of war or the conditional declaration. And the Article 2 of this convention subsequently mentioned about the notification of the state of war to the neutral power. If we interpret this, it can be seen that the state of war existed only with the declaration or the conditional declaration, and this is incoherent with Section 156 and Section 177 of Thai Constitution that the term declaration of war is located. In this case, Your Honor, none of the information in the agreed fact connect or link to any situation which is declaration of war. Therefore, the plaintiff would submit that state of war is irrelevant and need no further examination. The plaintiff now would like to draw the conclusion that the situation at a time that the compulsory license was ordered is neither the state of war nor the state of emergency, and therefore, the first condition under Section 52 is not satisfied. Moving to the second submission, Your Honors. The plaintiff will establish that the order in this case is not necessary for the purpose of national defense and maintaining security. Your Honor, may I draw your attention to paragraph 11 of the agreed fact. It is very common to see Ghanaian politicians campaign that promise to the people making the drug accessible to everyone with no cost. And therefore, after the election, the compulsory license was issued immediately. The decision is not of the national defense and the national security. Your Honors, in this case, the scope of national security following the fact in this case shall be examined whether that situation affects the general public as a whole or not, and whether the situation is with the complexity that can lead to the national crisis. However, the fatality rate in this case, as suggested by the fact, and infectious rate are inferred to be lower after the recommendation significantly. The concerning reinfection, that is the ground of the order to be issued, and also the concerning rate of mortality, is also limited to only certain group of people, not the public as a whole. And therefore, the plaintiff will conclude that there is no likelihood to cause the national crisis and it not affect public as a whole. And therefore, this is not for the purpose of maintaining national security. The situation is also irrelevant to the establishment of the naval establishment or the military establishment, since the fact did not lead to. And this also leads to the conclusion that it is not for the purpose of national defense as well. Your Honors, the defendant may argue alternatively, further agree that in some extent, the compulsory license in fact serves that aforementioned purposes, but the plaintiffs still believe that the act is not necessary. The defendant may raise some kind of the argument, such as the mortality rate, although it does not apply to the public as a whole, still considered a public safety, which is the important issue, in which the plaintiff disagree with this, and linked to the national defense and security for some reasons. Therefore, the compulsory license for the defendant is a must, but this cannot justify the necessity of the act of the compulsory license. Your Honors, in examining whether or not the act is necessary, one test, which is the principle of necessity, shall be applied. And if the purpose of the defendant here is to reduce the number of the infection and the number of the mortalities, there are various less intrusive means in which can be taken before affecting the right of the plaintiff. For example, lifting that recommendation to the enforceable measures for compulsory face mask in public space, or the social distancing in public space, or even enact the measures of work from home, but the fact turns out it's never been enacted. And since under paragraph 4 of the agreed fact, Ghanaian people prefer outdoor activities, and this leads to in-person communication inevitably. And ears spread from person to person through the contact of the bodily fluids. This can be seen that if we limit at the cause of the infections, it will reduce effectively the number of infection and the mortality as suggested under paragraph 8 of the agreed fact. Moreover, Your Honor, paragraph 12 of the agreed facts also ensures the plaintiff believes that the purpose of compulsory license in question is not of national defense or national security. Since expense arising from treatments of ES patients in a public hospital are free of charge as per its policy promised to people during the election campaign by the president. The plaintiff therefore would like to draw the second conclusion that the compulsory license in question is not for the purpose of both national security and the national defense, but the objective is merely politics and the act lacks necessity. Lastly, Your Honors, although the defendant argued on all aforementioned layers, the compulsory license in question is still unlawful. Your Honors, if applying interpretation from Article 31 Sub-Article E of TRIPS, the exercise of right through the compulsory license in this section is non-assignable. However, under paragraph 12 of the agreed fact, the government policy is to authorize another separate entity from OMID, which is BioGhanaian, by having OMID transfer or assign the information under the patent to BioGhanaian to produce the medicine under the patent. And therefore, the compulsory license in this case is still contradict to section 52, resulting in the unlawfulness of the order anyway. Your Honors, my co-counsel will address the issue of the unfair remuneration fee afterwards, and including the issue of the unlawfulness of the order to disclose the trade secrets. And if there is no further questions from Your Honors, this will conclude my submissions, and may it please the Court.
Yes, you may sit down. Await your questions will definitely come in due course. There are two issues at hand that we have to consider. First, that you have addressed quite ably and very satisfactory. The compulsory license issue. You may sit down. And the next question is about the trade secrets and the disclosure of the compulsory disclosure of trade secrets. We will hear from the second counsel for the plaintiff, and then the bench will put questions afterwards for both counsels. So if the second counsel for the plaintiff, if you're ready, then you may proceed.
Good afternoon, Madam and Mr. President. My name is Pantilapon Donsakun, and I'm too honored to stand here on behalf of my plaintiff, Cipher Corporation, regarding third and fourth claims. For third claims, whether defendant give the unfair remuneration to the plaintiff or not. And regarding fourth claims, whether defendant order to disclose trade secrets is lawful or not. For the third claim, Your Honor, plaintiff would like to address for two issues and submit for two submissions. For the first issue, Your Honor, plaintiff would like to address that plaintiff have the right to appeal to the court within the period specified under the law. According to the Patent Act, Section 52, Paragraph 2, Your Honor will see that the patent owner has right to has right to appeal to the court within a period 60 days as from the day that received the order. According to the fact paragraph 13, Your Honor, after the government order CR with Cipher decide promptly to appeal to the court. Therefore, plaintiff address the plaintiff has right to appeal to the court within a period specified under the law. For the second issues, Your Honor, plaintiff would like to address that plaintiff will be expected to suffer from losses due to the unfair remuneration given by defendant. According to the fact paragraph 3, Your Honor, due to the business model of Cipher, Cipher will be expected to break even from the R&D courses at the end of the third year. But at the moment that make the CL with government, Cipher still incur losses. Affirmed by the fact paragraph 13, Cipher would be expected to suffer losses around 50% based upon the revenues because the existing consumers of Cipher would be the patient in public hospital who change the mind to buy from the OMRD instead, Your Honor. Therefore, plaintiff will be expected from the losses due to the unfair remuneration given by defendant. Subsequently, Your Honor, plaintiff would like to submit for 2 submissions. For the first submission, Your Honor, plaintiff would like to submit that defendant undermine the requirement under the Thai Patent Act and Article 31H of TRIPS agreement. As aforementioned, Your Honor, that in Section 52 of the Thai Patent Act, the government shall give the fair remuneration to the patent owner. However, the law does not state clearly about the criteria to the word called fair remuneration, Your Honor. Respectfully to the regulation number 33 of the Intellectual Property and International Trade case, plaintiff would like to adopt TRIPS agreement to assist in terms of interpretation. According to Article 31H of TRIPS agreement, the patent owner shall have right to receive the adequate remuneration, and such remuneration must be adjusted upon case-by-case basis and take the factor of economic value into consideration. Still, Your Honor, TRIPS does not provide any criteria to the word called the adequate remuneration. Plaintiff would like to present the case from the CMS Gas Transmission Company versus the Argentina Republic. In this case, the exit bench ruled that the adequate remuneration must be based upon the full market value of authorization, and circumstance must be taken into account, Your Honor. For example, Cipher still incur losses could be considered as a circumstance in this case, and take the factor of the economic value into consideration. Your Honor, may I adopt the interpretation from Turkey? Most scholars in Turkey believe that the economic value must be interpreted the same way as the normal licensing agreement. Back to this case, Your Honor, according to the fact paragraph 11, Your Honor will see that the government ordered to make CL with Cipher and pay the remuneration at 1.5, which calculate based upon the price which OMRD sold. Your Honor will see that Defendant Act is not comply to any requirement under Article 31H of TRIPS agreement. Further, defendant does not take into account for the factor of the adequate remuneration or economic value into consideration. Therefore, Your Honor, plaintiff submit to Your Honor that defendant undermine the requirement under the domestic and international law regimes. For the second submission, Your Honor, plaintiff would like to submit that the rate at 1.5% based upon the price which OMRD sold is not considered as a fair remuneration, Your Honor. In this case, plaintiff would like to adopt 2005 Canadian guideline to provide, Your Honor, the appropriate remuneration. There are 4 main reasons, Your Honor, why plaintiff believe that this approach is very suitable in this case. For the first reason, Canadian guideline take the factor of the least developed country, hereafter LDC, into consideration. And in this case, Your Honor, according to the WHO guideline for remuneration, state clearly that the most useful approach must be the one that is easy and not too complicated. And third, Your Honor, this guideline provides a wide range of royalties, starting from 0.02 to 4% maximum. And last, this approach involves the HDI factor, which derives from the life expectancy, education, and also the economic metric, which is GDP here. Subsequently, Your Honor, may I affirm my submission by calculate the appropriate remuneration to Your Honor. May I present the model, which is 0.04 multiplied by 192 minus the ranking of the country here in question and divide by 191, which is the number of the countries in the HDI index, and then multiply again by 100 to make it into the percentage. According to the fact paragraph 5, Your Honor will see that Garland used Thailand as the model. Therefore, plaintiff would like to adopt the rank of the Thailand into consideration. Thailand rank allows 66 right now, so plaintiff would like to calculate the royalties based on this number. And the royalties, which is 2.6% based upon the generic price product. Therefore, Your Honor will see that the rate at 1.5% based upon the price of the OMRD is not considered as a fair remuneration under the law. For the fourth claim, Your Honor, plaintiff would like, as aforementioned by my co-counsel, has already established that the order of the defendant is not fall into any exception. As such, the defendant order could be considered as an infringement of trade secret. In this case, Your Honor, plaintiff would like to submit for two submissions. For the first submission, Your Honor, plaintiff would like to submit that Defendant Act is not fall into any exceptions under Section 72A and Section 72B of the Thai Trade Secret Act. According to Section 72A, Your Honor will see that any following act shall not consider as an infringement of the trade secret if such act necessary to the public health or safety. According to the fact paragraph 13, Your Honor will see that BioGarland has capability to manufacture the drug into the market. The know-how such as the method to extracting the raw material for better purification or the manufacture to improve the absorption of the drug. May I highlight the word better and improve. It is not considered as necessary for public health or safety here, Your Honor. And because only cipher patent claims are sufficient enough to produce or manufacture the drug into the market. As such, plaintiff believe that Defendant Act is not fall into the Section 72A of the Thai Trade Secret Act. Moving on to Section 72B, Your Honor. In this case, may I affirm my submission that Defendant Act is not fall into the exception under Section 72B. For the first reason, Your Honor, Defendant Act is not considered as an act undertaken to the advantage of the public interest. According to the fact paragraph 12, Your Honor will see that even though defendant hold the shares amount of 51% of the BioGarland industry, however, Your Honor will see that there is another 49% which could be held from the companies or private entities here. Therefore, it could not be considered as a public interest here. Therefore, plaintiff's first condition satisfied. And second, Your Honor, Defendant Act is considered as an act having commercial purpose. According to the fact paragraph 13, Your Honor will see that BioGarland can produce and sell the drug into the market under the trademark called BioGarland. It could be assumed from this fact, Your Honor, that because defendant intentionally to sell the drug into the market under the trademark called BioGarland to distinguish the product from other manufacturers into the market. And the third one, Your Honor, Defendant Act is considered as an act having the unfair trading activity. Because BioGarland does not pay for any cost of R&D, Your Honor. But at the end, BioGarland can produce the drug with the same efficient of the plaintiff. It's not surprisingly here, Your Honor, that BioGarland can sell this drug with cheaper price than plaintiff. Affirmed by paragraph 3 of the fact, for the past several years, Your Honor, Cipher generated the incomes from the pharmaceutical businesses. It could be assumed from this fact that BioGarland has intentionally to sell this drug into the same market of the plaintiff. And affirmed by the fact paragraph 13, there were some individuals, Your Honor, who were expected to buy the drug from BioGarland instead. It could be assumed from this fact, Your Honor, that BioGarland emerging into the market, which is the unfair trading activity to the plaintiff. Therefore, plaintiff submit to Your Honor that Defendant Act is not fall into any exceptions under Section 72A and Section 72B. For the second submission, Your Honor, plaintiff would like to submit that Defendant Order will lead to the infringement of the trade secret. According to Section 6, Paragraph 1 of Thai Trade Secret Act, Your Honor will see that the law requires the act of disclosure of the trade secret without the owner consent could be considered as an infringement of trade secret. According to the fact paragraph 11, Your Honor will see that OMRD shall disclose the trade secret to BioGarland. Here, the act of disclosure appears. Moving on to Section 6, Paragraph 2. The law further requires the requirement that such act must be in contrary to honest trade practice, Your Honor. May I present first ground, which is breach of contract. According to the fact, Paragraph 11, Your Honor, will see that defendant will have to sign the confidential agreement with plaintiff. There is no clear fact, Your Honor, state about the contents in such contract. Therefore, plaintiff would like to interpret allied with the law. If defendant would like to obtain the trade secret from the plaintiff, defendant will have to oblige by Section 72B of Trade Secret Act. However, in contrast, Your Honor, according to Statement of Agree Fact, Paragraph 13, OMRD shall disclose the trade secret to the buyer garland, which is considered as the unfair trading activity to the plaintiff. This is my conclusion that plaintiff would like to submit to Your Honor that defendant order will lead to the infringement of the trade secret. And lastly, Your Honor, plaintiff would like to respectfully request to the court that to render the CL in question is unlawful since the situation is not state of war nor state of emergency. And such act is not necessary for national defense and national security. And the remuneration given by defendant is considered as unfair. And the defendant act is considered as the infringement of the trade secret of the plaintiff. If there is no further questions, may I conclude my submission and may it please the court.
And since the responsibility of the counsel for the plaintiffs is collective one, so the bench will now put some questions to you both as the counsel for the plaintiff. So it's your choice who among you will answer the questions put forward from now on. So the relief sought by the plaintiff is whether it is the revocation, annulment, or setting aside the order of the newly elected Prime Minister of Garland and the order of the government of Garland concerning the disclosure of the trade secrets. So you seek this court to annul those orders as a sort of a judicial review of administrative action, or you simply request this court and whether this court had jurisdiction to sort of amend the compulsory order or the disclosure order to arrive at what in the views of the plaintiff are fair and reasonable terms, which is the relief sought by the plaintiff. Simply annulment or sort of amendment. You may take your time, and when you are ready, you can raise gracefully and answer. That's not in the law, I'm afraid.
All right.
Because this is the exercise. This court will now exercise the jurisdiction of the administrative court, because certain administrative action, judicial review of the judicial review of administrative action is vested in this court concerning the order from the executive. In this case, the newly elected Prime Minister very enthusiastically in the first week of his office, he ordered this compulsory license and disclosure order. Well,
in order to answer the questions,
yes, you.
May I would like to answer the question by first restate the questions whether I understand the questions correctly or not. So the first question of the honors is that whether the relief sought by the plaintiff is the annulment of the administrative action or the amendment of the order given by the defendant for both the compulsory license and the order to disclose trade secrets. And for the second question, your honors asked whether how can the court has jurisdiction. Is this correct?
well, we have the jurisdiction to announce, yes? Like the announcement of a patent decision from the Board of Patent, yes? So we do not have the jurisdiction to sort of amend. It's not like unfair contract terms that the court will exercise according what is fair and reasonable. If we find that the Prime Minister order is illegal, then we just announce it. Do you think we have jurisdiction to amend it?
Okay, that gives me a relief. I thought Your Honors already give the answer in which I did not yet explain. So, first thing to consider is whether this order is considered the administrative act or not. And of course, the administrative act is the act by the public authority in which, in this case, the defendant is in exercise of public administration, which in this case is the enforcement of the law that regulates, which have legal effects on the plaintiff, the concrete case, which in this case, we can see that the order was given to the individual authorizing the use of the right under the patent, as well as order the plaintiff to disclose trade secrets, which means this is on the concrete individual regime and have the direct external legal effect, which in this case, CIPHER is considered to be an external person. So both of the all the conditions satisfy that both the order in question is the administrative act. Now comes to the question whether or not the court has jurisdiction to annul it. My answer would say that in this case, the court has jurisdiction to determine whether or not the act is unlawful. In order to revoke the administrative act, that is the jurisdiction of the administrative court. But for the second one, the order of the trade secret, since the plaintiff established that the order will lead to the unlawful consequence, which might contradict to public order and good morals. In such case, it may not necessary to go for the revocation, since it will annul automatically.
Do you see this clearly? Annulment means abolish it. Everything is null and void, and that's it. Or we sort of look at the prime ministerial order and sort of amend it. Do we have the jurisdiction to do the latter? That's that very simple question. We need a simple answer.
For the order of the compulsory license, this court has jurisdiction to amend, since the law states clearly that the plaintiff can appeal the order and the amount of remuneration, Your Honors. But the answer for the trade secrets, there's no law stated in the law, and therefore, in that case, it's not subject to the annulments, which is in this jurisdiction.
So you request for the
for the first one, the compulsory license, the plaintiff respectfully relieve Your Honors to render the judgment that the order to compulsory license is unlawful, as well as amend the remuneration fee as it is appealed under this
So
court.
you're sort of satisfied with the merit, but not satisfied with the amount.
May Your Honors elaborate the questions?
Well, if you argue with the amount, it means that, well, the merit is justified, but the amount is not. So we just look at the amount of remuneration, i.e. the fees, reasonable fees payable.
No, Your Honors, the plaintiff, the first counsel of the plaintiff here argued that the merits, the condition is not the state of emergency or the state of war, and is not necessary to enact.
So if it's not qualified as an emergency, then the Prime Minister has no power at all.
Exactly.
So we should announce it.
Yes, Your Honors should announce if the first ground satisfied.
And if we announce it, are you satisfied?
Yes, Your Honors.
We don't have to consider about remuneration if there's an announcement.
But Your Honors, the layer that the plaintiff argued for the remuneration is that if the first two conditions was satisfied, then the remuneration is unfair.
All right, good. Now, second, you may sit down, and the second is that the burden of proof is on the plaintiff, correct? Yes, but there's a standard of proof involved. What do you think the standard of proof that this court will have to apply when you seek an annulment of the executive order, in this case the Prime Minister's order? Do you think that the court need to apply beyond reasonable doubts standard or balance of probabilities or any other standards, for example, clear and convincing? And the authority for your answer. If the answer comes from the second counsel, then the second counsel may gracefully raise and answer it yourself.
ตัว administrative act in this case มันเดี๋ยวนะเวลาที่จะเพิกถอนปกติ administrative court เขาจะสามารถ gather evidence in ได้แปลว่ามันจะต้องเป็น clear and convincing เพราะว่าปกติมันเป็นเรื่องของการเพิกถอนเพราะเราไม่ได้ฟ้องคดีอาญาฉะนั้นน่าจะต้องเป็น clear and convincing ใครจะตอบ Okay. So may I answer the second question again? So the standard in which the court should apply in the annulment, if the relief is of the annulment, is the standard of clear and convincing evidence. Your Honor, the reasons to draw the analogy is that because when the administrative act was to be revoked and subject to the administrative court, that court can gather its own evidence, which means that there's no need to prove the reasonable doubt. And if we apply the same logic to this case, it is sure that the plaintiff must prove which the clear and convincing evidence as well as the defendant have to prove, and who the burdens of proof in this case also bear on the plaintiff. But if the plaintiff can prove more convincing than the defendant,
this is a criminal case.
Your Honor, the relief is not about the criminal case.
This is a civil case.
Is
this a civil case? And what is the standard of proof of a civil case?
Clear and convincing, Your Honor.
Are you sure?
Civil case.
I thought Garland applies Thai law.
Yes, Your Honor, I'm sure that the standard of reasonable doubt is on the criminal case, and for the civil case.
Well, forget about criminal cases.
Yes.
Is this a civil case?
Is it a civil case? Your Honor, the plaintiff think that this is the civil case, Your Honor.
Yeah. And what is the standard of proof in a civil case?
It is clear and convincing evidence where one have to.
Okay, fine. If you insist so, right. Don't worry about the time, because justice will not be hindered by time constraint. And I'm very proud of these people. They are very competent in answering the question in distress. They try and try hard, and I only congratulate those professors who have so diligently and devoted themselves for teaching you and giving this new young blood to our law society in Thailand. Yeah. Okay. I have one or more question, and then my colleagues will have more difficult questions. This is just to warm you up. All right. Now you say that you have obviously cited TRIPS agreement, and the lady the lady council has cited many more countries and how they operate. Why Garland Court which is the last time I checked is an independent judiciary, independent country, need to follow TRIPS, need to follow Canada or Turkey, or, well, the court is well aware that Garland is a member of TRIPS, but TRIPS must be implemented into our domestic law, and the court is to follow the law. Why do we bother to look at international law?
การแลนด์รู้สึกว่าการแลนด์จะเซ็น TRIPS
You know, the rule of evidence is that the court would love to have direct evidence, not hearsay. So if one counsel tell the other counsel of the answer, the second counsel when answering will be hearsay, wouldn't it?
May I answer your questions from Your Honor? There are like 4 main reasons that plaintiff believe that Your Honor should listen to the TRIPS agreement. For the first reason, Your Honor, plaintiff would like to affirm again that from my part, that my submissions, plaintiff would like to draw the analogy of the law which combine international law into domestic law. And because there are sources of law which we all can respect. For the first one is domestic law. Second one is Supreme Court decision or cases in such country. And for the third one is international law or international authorities. That's why, Your Honor, in this case, as you know, Your Honor will see, for example, about the remuneration. You know, we'll see according to the patent section 52, there's no clear criteria about the word called fair remuneration, Your Honor. So plaintiff would like to adopt or use the TRIPS agreement, which is international law, to assist in terms of analogy. And apart from that, Your Honor, plaintiff would like to interpret some elements based upon the assistance from the TRIPS agreement, because plaintiff believe that according to the fact paragraph 5, Your Honor, we'll see that Garland has joined. Do you have an
authority for that?
Authorities for
using TRIPS or the Thai court applied TRIPS ex officio on its own right. Have you seen an authority for that?
May I answer your question? That
yes, of course.
For example, in trademark, Your Honor, there is there is a conditions about the trademark which we adopt by the TRIPS agreement. And in this case, Your Honor, we'll see that the authority in this case is that TRIPS can be used to assist in terms of the guideline for remuneration.
Yeah, you simply just cite the number of the Supreme Court, and that is that. Now everybody, all law schools, all law students can access to the decision of the Supreme Court, and you just say, that's number so and so. But if not, that's good enough.
Yes, thank you, Your Honor. May I affirm and highlight again from my submission? I have one case from CMS Gas Transmission Company versus the Argentina Republic. In this case, the international dispute settlement ordered that the adequate remuneration must be based upon the full market value. Your Honor, we'll see that in this case is international law, like international regimes about the dispute settlement, which could be used the TRIPS agreement in terms of assist as well, Your Honor.
Thank you. Now, you have anything to add?
May I elaborate a little bit on the standard of Supreme Court decision? Although both of the plaintiff counsel highly accept that we forgot the number of the Supreme Court decisions, but the details of the case is that in that case the court don't know. There is no the meaning of what is public sector in the Trademark Act. And in that case, the court have adopted the TRIPS agreement to interpret that the public sector is sufficient if it is a relevant public sector related to those. I think the case is related to some kind of the football logos, Your Honors.
Yeah, well done, Mark. The gentleman who wrote that decision is over there. So in English courts, all the counsel can cite the decision of the court, and why not Thai or Garland counsels? Yeah, and everybody can have access to all the court decision and authorities. You need to have a tablet or a notebook and to access all those authorities right there. Yes, even from a mobile. Right, good. Now, you'll be facing more difficult questions now, just as a warm-up. So please, madam.
I think
Justice?
I do not have any more questions because it seems you have facing enough difficult time. No question for the plaintiff.
Yes, that's very kind of you. And you got away with it. Now, counsel for the defendant. First counsel, you will be facing some of the toughest time as well. Not to worry.
Your Honors, and may it please the Court, my name is Napacha Jaskula and I'm honored to be representing on behalf of the defendant, Garland's Prime Minister today. In response to the plaintiff's submission, I will be addressing on the first two issues. First, the compulsory licensing measure is stated in an emergency as required by the law, and second, the compulsory licensing measure is necessary for the purpose of maintaining national security. Following my submission, my co-counsel will then address on the remaining issue that the compensation offered by Garland constitute a fair remuneration, and the order compelling ciphers to reveal its trade secret is lawful. For the first issue, the defendant submits that the compulsory licensing order is issued during a state of emergency in accordance with the TRIPS Agreement, Article 31B. In comparison to Thailand compulsory licensing order in 2006 for medical coping with HIV and AIDS, according to the Department of Disease Control statistic report, the number of the AIDS infection since 1984 until 2007 was approximately a total of 300,000 people and an approximate death of 90,000 people within these 23 years. In this case, the facts state that a new disease called AIDS has widely spread and infected 5 million people in Garland and causes death of 200,050 people after the outbreak, not to mention the rising of the fatality rate after the first 6 months. Statistic of the ears infection rate and fatality rate in this case are high enough to consider it a state of emergency. In Clause 5C, the Doha Declaration gives each member to determine what constitutes national emergency. Further illustrates examples of diseases that national emergencies such as HIV. In comparison to this disease, HIV is passed on through blood, normally by sexual contact, but not through spitting, sneezing, or coughing, unlike AIDS, which spreads through contact with bodily fluid, similar to the spreads of influenza virus, which spreads more easily just by coughing, sneezing, or even by talking. And due to the way of life of the people in Garland that prefers outdoor activities, which leads to in-person communication, even makes it worse. Though the defendant acknowledges the severity of this situation, it could only recommend its people to use face masks and could not shut down restaurants and shopping malls due to the concern about the country's economy. However, when the plaintiff expressed its interest to develop a cure for this disease, the defendant did indeed fasten all the regulatory procedures so that the medicine would be available for public use as fast as possible, and all the steps were successfully taken in only a year after the beginning of the pandemic. This shows that the defendant acknowledged the severity of this emergence and took this situation seriously. Although the Doha Declaration dispelled the myth that compulsory license should be limited to emergency situations by confirming that the member was free to determine the grounds and the compulsory license could be issued, which creates opportunity for the members to adopt measures necessary to protect public health according to the TRIPS principle in Article 8. However, there is no doubt, Your Honor, that the ear epidemic is an emergence of public health crisis that falls within the meaning of Clause 5C that justifies the use of compulsory license. This concludes my submission on the first issue. Now I will be addressing on the second issue that compulsory licensing order is necessary for the purpose of maintaining national security. According to the Presidential Studies Quarterly, a scholarly journal on national security and national defense written by Lee H. Hamilton, it clarifies that national security shall not be defined specifically in terms of military posture that is linked to the protection of the nation from physical assault, but indeed it shall be defined with regard to the national interests, the loss of which would threaten the fundamental value and the survival as a state. One of the elements and necessity as a state is its population. According to the fact, the situation that Garland is facing results in illness and death of its people. If such nightmarish situation continue, Garland will face a great loss for its country. With the intention to cope with the situation and to meet basic human rights such as medical care, the defendant took action by issuing compulsory licensing order CIPITC's patent to be able to provide medical access for its people with low income and to stop the rising of reinfection rate along with the mortality rate. This action is necessary for a least developed country like Garland, which its technological advancement is so low that it cannot invent or produce its own medicine. Therefore, it needs to rely on developed country like Insomnia. Even though Garland is considered as least developed country, it recognizes the importance of intellectual property law and strives to make the protection trusted internationally by joining the TRIPS agreement without making any reservations. According to the TRIPS agreement, Article 66, Garland will not be obliged with respect to pharmaceutical products to implement, apply, or enforce rights provided under Section 5 of Part 2 of the TRIPS agreement until 2033, as it is the least developed country with special needs. Meanwhile, Insomnia is also a member of the TRIPS agreement, therefore it shall recognize the special need of Garland in respect of maximum flexibilities in the domestic implementations of laws, as particularly the use of compulsory license measure. However, the defendant's decision was to respect the plaintiff's rights by legally issuing compulsory license on the grounds and condition that complies with the TRIPS agreement and its domestic law, as the compulsory measures stated in Article 31B of the TRIPS agreement that it could be used without authorization in case of national emergency. Nevertheless, the patent holders needs to be swiftly notified, and it is exactly what the defendant did. Moreover, the TRIPS agreement does not and should not prevent members from taking measures to protect public health. Therefore, Garland, which is facing an epidemic emergence, shall have the right to protect public health and promote access to medicine for all its people by using the provisions in the TRIPS agreement, which provides flexibilities such as compulsory license measure. And indeed, the compulsory licensing order is necessary in this case due to the lack of technological advancement and low economic development of Garland, which cannot rely on itself to research and develop its medicine for the people. Furthermore, the foreign manufacturing companies which seek profit from pharmaceutical business such as Cipher sells drugs at high price. But the majority of the population in Garland are low-income families which cannot access or afford high-priced drugs. On top of that, the AIDS epidemic spreads easily and quickly infected its population. Therefore, Garland could not consider the option to negotiate with the plaintiff to lower the price of its medicine instead of issuing compulsory license. The process would consume time, and whether the negotiation would be successful is unreliable. With no time to lose because of such ongoing epidemic emergence, it is necessary for Garland to issue compulsory license order, Your Honors, and that this order shall be enforced until the epidemic is over, according to the TRIPS Article 31C, F, and G. Additionally, we ask the plaintiff, as a developed country member, to provide incentive to its enterprises and institutions to promote and encourage technology transfer to least developed country members such as Garland, for it to explore the possibility of its own pharmaceutical production and be able to rely on itself in the future, according to the TRIPS Agreement Article 66, Paragraph 2, which is then reaffirmed in the Doha Declaration. This concludes all my submission. I may now leave the floor to my co-counsel. May it please the court.
Thank you, counsel. Thank you, counsel. Counsel for the second counsel for the defendant, if you are ready.
Your Honor, and may it please the court. My name is Picheda Amraratana, and I'm honored to be representing on behalf of the defendant, Garland's Prime Minister, today. Firstly, we submit that the remuneration offered by Garland at the rate of 1.5% of the selling price of the medicine purchased constitutes a fair remuneration under the law. Your Honor, based on the provision in the TRIPS Agreement, Article 31H and Section 51 of Thailand's Pardon Act, there's no value specified of how much amount will be adequate or the formula calculated for the remuneration. However, it is specified as such compensation should be determined by considering the individual circumstances and take into account of the economic value of authorization. If we look deeper when interpreting the term economic value of authorization, it can be seen that if the patent holder allows the production and distribution of the product under the patent and generates significant profit, the rate of the compensation should be set at a higher rate. In this case, the use of authorization by Garland is not for commercial, but rather to meet the demand of this particular medicine and at affordable prices and timely access to the people in Garland. Your Honor, the Doha Declaration, paragraph 4, also clarifies that the TRIPS Agreement should not hinder measures taken by members to protect public health, emphasizing its interpretation and implementation in support of members' right to enhance public health and access to medicine for all. We see that the interpretation mentioned earlier does not have adverse effect on the right holder cipher and aligns with the intended purpose of the Doha Declaration, which aims to ensure the access to medicine for those in need. Even though the plaintiff have claimed that the plaintiff have to sell their own drugs at the higher price to break even at the end of the third year and turn profitable in the fourth year due to the high cost of research and development. However, Your Honor, the clinical trial phase of Cipher is indeed shorter than the other medication, as the production timeline is short, with approximately 1 year. Generally, the clinical trial phase consists of at least 3 phases which result in years before publicly use. This shortened trial duration would surely reduce the research cost. And Your Honor, Garland is considered a least developed country. Lack of technological capabilities to develop and research their own medication. Most of the people in the country consist of low-income families inaccessible to effective drugs, and they have always pressured the government to take actions for the excessive prices of the medication. Despite these conditions, Your Honor, Garland still consistently offers satisfactory rate of compensation and have not exploited these rights without providing appropriate compensation to the right holders, despite the country's limited financial resources. Practically, countries declaring CL pays a very small amount of the compensation, such as Thailand, which used to pay only 0.5% of the drug's value, or an actual example in the United States, where the United States apply CL without paying any fees or compensation in the case of Federal Trade Commission versus Xerox Corporation. Despite being the developed nation with ample resources, Your Honor, United States still apply this measure. In this case, the rate of 1.5% is a significant amount due to the fact that there are about 5 million people in the countries in need of this medication, and Garland did not obstruct or prohibit Cipher to sell their own drugs. Thus, this calculation does not take into account of the original selling price set by Cipher at a higher rate for the consumer with confidence in Cipher's trademark and the sufficient power to afford this medicine, which aligns with the TRIPS Agreement Article 31D that this right shall be non-exclusive. Therefore, we submit that the compensation rate of 1.5% of the medicine purchased constitutes a fair remuneration under the law, since it complies with the procedures and conforms the goals of TRIPS Agreement and Doha Declaration, and it is a substantial amount for a country like Garland, which facing a major crisis. I will now address the last issue raised by the plaintiff. We submit that the order compelling Cipher to reveal trade secret is lawful. To support this, the TRIPS agreement does not expressly or impliedly prohibit government from compelling trade secret. Your Honor, it is important to first explain how or when the trade secret best serves public uses. The know-how regarding manufacturing processes, including the methods for extracting raw materials to enhance purification and the manufacturing techniques which increase the drug absorption, is particularly valuable because Garland is currently struggling with the severe widespread of EARS, prompting the Garland cabinet to declare national emergency. And also, the reinfection rate and the mortality rate continues to rise among those who cannot access the medicine. Therefore, the required know-how will enhance the effectiveness of the drugs to treat EARS patients more effectively. Back to the TRIPS agreement, Your Honor, Article 39 stated about the protection of the undisclosed information with a focus on preventing unfair competition and the use contrary to honest commercial practices. The interpretation of this article applies only to protect against these two offenses. It is unlikely that the TRIPS agreement prohibits government decisions to compel sharing such information to address the public needs, as the recited prohibitions focus on commercial morality. The Article 39.3 also restricts disclosure by government of such certain data. The government may disclose such information to commercial parties where needed to protect public health or where doing so will not result in unfair competition. Again, what is unfair in this context is unlikely to include what the government requires to address the public health needs. And Article 8 of TRIPS agreement also support the member countries in adopting any necessary measures to address the public health. In short, TRIPS does not and cannot prohibit member countries from compelling trade secrets to address public health needs. Moreover, Your Honor, Garland has scheduled a meeting with Cipher to sign a confidentiality agreement. This reflects their intention to keep the information confidential. Permitting the BioGarland company to access to the know-how is to provide effectiveness to to the drug to the citizen, and the production under biogarland trademark is to cover expenses arising from treating ears patient in the public hospital free of charge. Your Honor, Garland is indeed the least developed country, and the developed country like insomnia should show understanding according to the Doha Declaration paragraph 7, which granted exception to pharmaceutical products and extended to 2033 by TRIPS Council. However, if Garland, being a least developed country, is not obliged to safeguard patent and trade secret, the government still has taken all necessary steps to respect CIPITC's right. For example, in the COVID-19 case, Your Honor, the Doctors Without Borders oppose such strong trade secret protection for biopharmaceutical industry. They're supportive of TRIPS waiver and describe it as a life-saving move by India and South Africa to prioritize human lives and enable countries to effectively combat the pandemic by expanding the production of an existing COVID-19 medical tools. As you can see, that trade secret can have created bottlenecks in the global vaccine distribution effort. Even with access to patent, trade secret may block the best way for patented information to be implemented. Especially in pharmaceutical field, Your Honor, we believe that human lives should be prioritized above all else. Utilizing everything and making every available effort to address public health issues is the true core of TRIPS agreement and Doha Declaration. To conclude, Your Honor, the compulsory licensing in Garland is done in accordance with the law and in line with the provisions laid out in the TRIPS Agreement Article 31. Garland finds it necessary to employ compulsory licensing measures because the continuing spread of AIDS still causes fear among the people of Garland due to the inability of infected to produce natural immunity even after exposure. Without CIPITC's drugs, which are quintessential for the people of Garland, would absolutely bring back the nightmarish situation. This concludes my submission. May it please the court.
Thank you, counsel. My noble and learned friend on the left would like to put questions to the counsels for the defendant. So please listen carefully and answer.
Thank you, Your Honor. I have only one simple question for the counsel for the defendant. As I listen to your legal argument, your main reason for using the CL and also forcing the cipher for disclosing the trade secret is the public health concern. But my question is that, don't you think that using the CL and ordering cipher to disclose the trade secret might actually backfire? That means cipher may stop invest in the territory of the Garland soil. In the worst case scenario, maybe Garland may withdraw all the investment in Garland territory, and other countries may follow. They don't invest in the Garland any longer. So how can you deal with this situation? If you were the representative of the Garland state, so how can you make the recommendation to the government of Garland to deal with this situation if it happens?
First, I would like to address that the compulsory license.
Could you speak a little bit louder, please? Yeah, all right. Oh, there's a mic. Is there a mic?
Hello. Okay.
Yes. Yeah. Okay. Good. Sorry. Go on.
I would like to address that the compulsory licensing order actually have the condition to the patent holder still have the right over its patent, over its invention. And with compulsory license, they still have the exclusive right. And the market is not, the pharmaceutical market is not just in our country, Garland, but with their exclusive rights that they have over the patented invention, they could use this to distribute their products to other countries that needs pharmaceutical products as well. So I would say that, and also there is a remuneration for the patent holder as well, not just we use it for free.
I'm not sure you answer my question because this question is not directly to the law. I asked the kind of the policy because you have to assume that you are not only the state in the world, and in fact you may have to rely on other countries because you are the least development country, especially in the producing the medicine. So if you use the CR, you order them to disclose the trade secret, and of course they are involuntary to disclose the trade secret. But how can you deal with the future? How can you survive in this world?
Yes, Your Honor. Of course, they would not be pleasant with the use of compulsory licensing order because it's not voluntary. And I think that maybe after the use of this compulsory license order, if the situation in the countries get better, they could negotiate with each other on the terms and agreements that the least developed country could maybe offer something that they have for the developed country that might be beneficial for them in the future.
Madam Justice?
Since the chief of the judge panel say I'm very kind, my question is very easy. Yeah, my question is about trade secret. And is there any provision under the Thai law that allows state agency or government authority to legitimately disclose any trade secret of any individual or any private owner?
Yes, indeed, Your Honor, there's a Section 7.2a and Section 7.2b that states about the exception for the government or agency to disclose or use of the trade secret legitimately.
Do you think it's applicable to this case?
Yes, Your Honor, because both of the Section 7.2a and Section 7.2b state that the use or disclose of the trade secret should be used for the public needs or the public benefit or interest.
Easy one.
Okay, we pride ourselves to have associate judges in our court, and one of the associate judges that sitting here is called the Iron Lady of the Department of Intellectual Property of Thailand. So do you care to have any questions or just
Thank you so much. But I think that I very worry about the trade secret in Garland when she had defense on this case. Then I have no questions. Thank you.
So you may take this in your rebuttal. You have time for rebuttal. So if she has concern about trade secret, you will address your concern in your rebuttal. So this is just a sort of warning. And another associate judge of us is a very successful entrepreneur and a young entrepreneur. And do you have any question?
Yes, sir.
Yeah.
Refer to the compensation offer that you refer to the economics value, which you focus for the non-profit for the sake of public health, and also you refer to the Doha Declaration, and also the R&D in clinical stage, less than the normal stage for 1 to 3 years, which is very clever refer. So is there any solid law that we can refer for the compensation under the law that can be clearly or solid support your 1.5%?
Your Honor, there is no such phrase in the law or solid law that actually specifies of how much amount would be adequate, but the term adequate can be refers to something exactly equal in terms, but in the Article 31H of the TRIPS agreement stated that the adequate remuneration followed by the phrase in the circumstances of each case, taking into account of the economic value of authorization, which I mentioned earlier about interpreting the term economic value of authorization. Your Honor.
Now, you may sit down, and I will have to ask you a question or two. But what is alleged, or what was alleged by the plaintiff, is that your Prime Minister's order, both in compulsory license and later on the disclosure order, are motivated by politics. They are politically motivated to be used as a bargaining chip in order to bargain for a more reasonable royalty fees and terms. Although this is a legal dispute, but legal disputes of this kind, investment dispute, an investor from a foreign country would always argue that any decisions made by the executive, when the executive takes it into his or her own hands, like in this case, this is a compulsory license exercised not by judicial power, but by executive power. So it's political in its nature. What do you say to that? That this court, the court of Garland, must deliver justice, and as the saying, justice is not only be done, but must be seen to be done. So how do you counter-argue that the orders are politically motivated? Yes, if you are ready.
Politically,
could you speak up? The engineer, is it all right? Oh, you haven't spoken.
In this case, the election, they have to be they have to have policy on this ears medicine for its people because the epidemic is still ongoing and the reinfection rate is still on rise and they have to
when you do the political rally just before your election, what is the agenda that free medical service and compulsory license and so on?
It's an important situation at that time.
We must not be confused by the plaintiff's statement about the political issue is because the political issue here is irrelevant to the subject we are discussing here. We are focusing on the emergency of the situation of Garland to declare a state of emergency, using EARS as one of the campaign or policy to provide EARS drug accessible for everyone without cost is necessary and crucial as it is and urgent and the prioritized matter of public welfare. It is not surprising that you can see that politicians make this a key policy when running for an election. And why does the political or the politicians have to make the drugs free of charge is because we must provide medication to our citizens.
We mean?
Garland
Yeah.
government.
Not the politician.
The Prime Minister. The Garland must provide medication to our citizens free of charge is because, as mentioned, the country consists of low-income families and it is in least developed country. The majority of people here have extremely low income. They absolutely cannot afford expensive medication and they are already struggling to make ends meet. And with a severe widespread of EARS, if we were to expect them to spend their limited funds on costly medication, it would be an impossible burden. And by leaving those without money, inaccessible to medication would essentially mean that if you don't have money, you're condemned to death. And we think that this isn't fair to the citizen, all citizens. We should treat them in humane manner, Your Honor.
Oh, yes.
Fatality rate has reduced, but in the fact it's stated that the reinfection rate along with the mortality rate of those inaccessible on the medication was still on rise. So the inaccessible, for those inaccessible, we should not forget that the majority of the population in Garland are low-income families. They can provide and can access drugs. Yes, Your Honor.
Yes, I just like to point out that in advocacy, when you are pleading from your heart, like you two just did, it is much more powerful than reading from a text. So in other words, you look at them into the eyes, or look at the court in the eyes and say, this is realism, not motivated by politics. And whether it works or not, another matter. But this is advocacy. You probably should have read less and preterm from here, right? Okay, you have more or less another 10 each for rebuttal and sir rebuttal. You may start now.
Mr. Chief Justice, Your Honors, and may it please the court. In this 10 minutes, the plaintiff will do the rebuttal on the following points. Firstly, the defendant has mentioned the situation in which Thailand compulsory license for the HIV case to draw the analogy to the emergency in this case. But the compulsory license issue in question of the HIV situation is Section 51, which is not the state of emergency and therefore shall not be used. The defendant then cite Doha Declaration, which would, in fact, from Article 5b, that member has the right to grant compulsory license and determine the grounds, and Article 5c of Doha Declaration that member has the right to determine what constitutes the national emergency, highlighting the word determine. This shall be interpreted from the emergency decree, which is domestic law, but the defendant did not argue in that way. The defendant then used the number in the first 6 months to claim that the situation is emergency. Your Honor, after the recommendations, the number of fatality is significantly reduced, and from that time to now, it is already 3 years. The number at the emergence point cannot be used to determine the current situation. And although interpreting that the situation in the first 6 months is emergency, right now it is not anyway, since in fact the state of emergency under Section 5 of Emergency Decree limited to only 3 months, which extension of more than 3 months per each extension. Your Honors, then we move to the claim of the necessity on the national defense and security. First thing to mention is that the defendant only argued on the point of national security, but the condition of Section 52 is that it must be necessary of both national defense and national security. By not arguing, the plaintiff will deem the defendant accepted that is not of the purpose of national defense, and therefore the condition is already not satisfied. The defendant argued further that the nature of compulsory license and the measure is not the same, since right now the defendant would like to focus on the treatment. But in this case, Your Honor, there's no shortage in pharmaceutical product, and also the solution by the compulsory license is to not solve the problem at its cost, since cipher product is medicine, not vaccine. But taking into account of the defendant's argument, there is also another less intrusive means in the regime of compulsory license anyway, which is Section 51, negotiate first on the remunerations. Your Honors, the defendants then further argue that epidemic is a part of national security without any authority. It is true that epidemic is a part and included in the National Security Policy and Plan BE 2566 to 2570, but the epidemic is not automatically considered a national security concern, since the criteria to determine is to see whether the problems or the situation is which complexity tends to cause the national crisis and that affect the general public, not only a particular group of persons in concern. Moving to the point of the unfair remuneration fee, Your Honors, the defendant used Thailand as a model, which in the past the rate is only 0.5%, and it is true that Thailand once compulsory license import the HIV medicine with that rate. But that situation occurred 16 years ago, and Thailand at the time also faced international criticization, including sanctions from the United States. And it can be seen that during 2007, Your Honors, Thailand HDI rank is 82 out of 188, and the remuneration rate at a time shall be 2.28% of the generic price, which justified the criticism. However, the case never been decided whether it is fair, and this history cannot be used to be the standard of both sides. The defendant then mentioned that the Garland rank is lower, and there are 5 million, the Garland is least developed country, and there's 5 million people in need of the medicine. But in fact, Your Honor, the defendant may understand the fact wrong, since the fatality rate is 5%. Since the fatality rate reduced to only 50,000, it means that the number of the infectious also reduced as well. And in order to cope, another issue is that low income for the defendant is not inaccessible. Low income doesn't mean that they cannot buy drugs in the pharmacy. Your Honors, the defendant first argued that the production timeline is short because the defendant already shorted the process, but that is on the registration of the patent, not on the research and development process. Therefore, the cost in this sense is irrelevant. And then, defendant argued, helping people is more important than the profit of the plaintiff. We must provide the drugs accessible to everyone. And the plaintiff will say that, according to this argument, Your Honors, it is the mission of the state to struggle to find a way to give the medicine to everyone, but not the obligation of the cipher or the plaintiff here to suffer the unfair remuneration fee. Moving to the claim of the trade secrets, Your Honor, before we move to the claim of trade secrets, Your Honor, the defendant did not establish any authority of where is 1.5% from OMID rate come from, and which any authority, Your Honor, the calculation is manifestly infringe the guideline anyway, since the guideline normally calculate based on the market price of the product, not the OMID sold price. For the issue of trade secrets, Your Honor, The defendant did not mention the ground in the domestic law to order the disclosure. The defendant have mentioned about Article 39, subsection 3, sub-article 3 of the TRIPS, but that is only the case where the state can require the disclosure for the purpose of approving the marketing. In this case, it should be separate that the situation is not of the same. Another ground that the defendant may raise afterwards is under Article 73b of the TRIPS agreement, but the plaintiff would like to ensure in advance that that only possible to compel to disclose in the case of emergency is international relation, for example, the armed conflict, and it must be for essential national security, which limited to only protection of territory and maintenance of the internal law only. Your Honors, the defendant then argues that it is a must since there is a public health and Garland lacks of technology, but there is no shortage of the drugs since the plaintiff already established the company in Garland. And if the defendant say that there is no power to produce, how can OMRD and BioGarland is to produce? And this is in contradiction of their own arguments. The defendant also mentioned a little bit about the public safety and the public interest without any elaboration, Your Honor. This will lead back to the point that the defendant also contradicts their own arguments. If the defendant decides to promote public safety, this means that the measure is to safeguard people from being infected first, not giving away the medicine when they are infected. And the public interest in this case is to cure the disease in this case. The manufacturing process is only enhanced for the manufacturing purpose, not in the result that the drugs will have measure or more effective, and therefore there's no necessary. Back to the public health, Your Honor. In fact, in the WHO definition, public health refers to all organized measures to prevent disease, highlighted the word prevent disease. The medicine, again, is not a vaccine. It is used to cure the disease, not to prevent the infection or to provide any immunity, Your Honors. And the plaintiff, therefore, would like to request the court to render the judgment that, first, the compulsory license in question is unlawful, since the situation is not the state of war and emergency, and that there is no necessity act for national defense and security. Second, the remuneration under the compulsory license is unfair. Third, the order to disclose the trade secret is unlawful. Lastly, Your Honor, the plaintiff understands the situation of Garland, but we want to display that the order in question is unlawful. The compulsory license is not in accordance with Section 52. In fact, the plaintiff failing to assist Garland as reflected from the decision to commence research and development immediately to produce a medicine of years, and that will take 3 years to strike an event. And by establishing a pharmaceutical factory, it indicates a desire to reduce cost already. Furthermore, plaintiff has confidence in Garland all along, since Garland always gives satisfactory remuneration rate in paragraph 10 of the agreed fact. Therefore, the plaintiff believes the defendant should not proceed in this unlawful manner, but instead finding another solution such as negotiation, and has been done successfully in the past. This concludes my submission, and may it please the court.
Thank you, plaintiff. Defendant, please, if you need the sir rebuttal.
ครบทุกประเด็นเนาะ
Your Honor, I may now address and conclude our submission according to the 4 issues. The first issue is that the plaintiff have claimed that the situation is not a national emergency due to the fact that Garland government have only recommended the use of face mask policy. However, I may remind the court that Garland is not such a wealthy country as it is a developed country. The use of face mask policies and allowing the businesses to normally operate is to sustain the economy. These businesses were driven by most of the people whose age group are low risk of death. Where the plaintiff have said that the people who have died from ears already have the other disease, such as the heart disease or something, and when they get infected by ears, they died. However, I may argue that if there's no ear, these risk group of people would not have died, anyway, because if they only have the heart disease without ears, they wouldn't have died this fast. And the reason why we did not implement a compulsory licensing measure from the beginning is because applying these measures is not something that can be done immediately when a severe epidemic occurs compared to the case of HIV, where it took over 22 years for compulsory licensing to be implemented. Garland has respect CIPITC's right and provide our maximum convenience to the plaintiff, as it is impossible for the patented drugs to finish all procedure within 1 year without skipping. However, Garland has flattened out the steps in the patent insurance process within 1 year, which is significantly faster than the time taken by other countries. For example, Thailand takes approximately 55 months to grant a patent, or faster in the United States with a turnaround time of 22 months through the USPTO. On the third argument that the plaintiff have claimed of the high cost of research and development, Your Honor, the cost of recouping for the medication produced by CIPITC is indeed likely to be lower compared to other medications. This is because the medicine has a shorter production and distribution timeline, which is around 1 year, significantly shorter than many other medications. The shortened clinical trial duration also reduces research costs. Generally, to complete the first 3 phases of clinical trial can take 10 to 15 years or longer before starting the approval stage. Therefore, if one were to claim that the cost of the medication is exorbitant, we affirm that the 1.5% rate of compensation provided aligns reasonably with the R&D costs derived from this particular medicine. For the trade secret issue, Your Honor, the use of CL does not necessarily require the state to become the producer of the medication. The government can authorize third parties to be the producer, including foreign companies, as specified in the provision of TRIPS Agreement Article 31. In this case, BioGarland is the company in which the state had a significant share in, implying trustworthiness and a genuine commitment to the public interest. The production under the trademark of BioGarland is also intended to generate revenue, covering some of the expenses incurred by the state in treating ES patients. As we mentioned earlier, it is essential not to leave those without money means to die. We must act in a human manner towards our citizens, regardless of their wealth. Therefore, providing the know-how to BioGarland to speed the production and distribution of the medication to the people aligns with the intention of the TRIPS Agreement. And Your Honor, the Doha Declaration, paragraph 4, also emphasized that the TRIPS Agreement should be interpreted and implemented in a manner supportive of the WTO members' right to protect public health and promote access to medicine for all. The Garland, being an least developed country, can have maximum flexibilities in interpreting the law. Therefore, Your Honor, we submit that the court shall decide that the state of emergency and the national security and national defenses of Garland is lawful, and the order compelling CIPITC to reveal the trade secret is also lawful, and the 1% rate of remuneration is lawful under the law. This concludes my submission.
Thank you. Thank you both counsels for both parties, which perform very well, and this is very enlightening and yet entertaining session of oral argument from both of you. So the court will adjourn and the judgment will be given in due course. Thank you very much.
At this moment, the mock trial has ended, and the court will retire to deliberate and determine the first prize winner. On this occasion, you are cordially invited to watch an interview with Judge Sakapan Jitjong, Secretary of the Central Intellectual Property and International Trade Court.
สวัสดีค่ะพักเบรกกันสักครู่นะคะสำหรับการแข่งขันว่าความในศาลจำลองประจำปี 2566 รอบชิงชนะเลิศค่ะแล้ววันนี้ค่ะดิฉันก็ได้รับเกียรติจากท่านศักพันธ์จิตจงค่ะเลขานุการศาลทรัพย์สินทางปัญญาและการค้าระหว่างประเทศกลางซึ่งท่านจะมาร่วมพูดคุยถึงภาพรวมโครงการกับเราในวันนี้ค่ะสวัสดีค่ะสวัสดีครับท่านเลขาคะเป็นยังไงบ้างคะสำหรับการแข่งขันจากน้องๆทีมภาคภาษาไทยแล้วก็ภาคภาษาอังกฤษอะค่ะ
ครับเรียกได้ว่าสนุกและตื่นเต้นมากๆนะครับสมกับเป็นรอบชิงชนะเลิศของโครงการแข่งขันว่าความศาลจำลองของศาลเราในปีนี้จริงๆนะครับเพราะว่ากว่าน้องๆทั้ง2ทีมนะครับทั้ง4ทีมในวันนี้เลยดีกว่าทั้งภาคภาษาไทยและภาคภาษาอังกฤษจะได้ฝ่าฟันนะครับเพื่อนๆจากรอบ8ทีมรอบ4ทีมจนถึงรอบชิงชนะเลิศนะครับแล้วได้แสดงเหตุผลทางด้านกฎหมายนะครับไหวพริบปฏิภาณนะครับต่อสู้กันจนถึงรอบชิงชนะเลิศอย่างที่ทุกคนได้รับฟังกันแล้วนะครับก็เรียกได้ว่าทำกันอย่างเต็มที่และสมกับเป็นคู่ชิงชนะเลิศจริงๆครับ
ดุเดือดกันเลยทีเดียวนะคะค่ะก็อยากจะให้ท่านเลขาค่ะช่วยเล่าที่มาที่ไปของโครงการนี้หน่อยนะคะว่ามีที่มาแล้วก็ที่ไปยังไงบ้างอะค่ะ
ครับจากที่ทุกท่านทราบนะครับภารกิจหลักของศาลนะครับก็คือการตัดสินคดีถูกไหมครับแต่ว่านอกจากนี้นะครับจากเรื่องการตัดสินคดีแล้วนะครับเราก็ยังมีภารกิจรองนะครับที่เราจะพยายามส่งเสริมสนับสนุนนะครับให้บุคลากรรวมถึงประชาชนทั่วไปนะครับได้รู้จักกฎหมายที่อยู่ภายใต้เขตอำนาจของศาลเรานะครับไม่ว่าจะเป็นกฎหมายทรัพย์สินทางปัญญานะครับหรือกฎหมายการค้าระหว่างประเทศนะครับซึ่งนอกจากการที่นักศึกษามาดูงานที่ศาลเราเป็นระยะเวลาเยอะหลายทีมและหลายโรงเรียนหลายหน่วยงานทั้งในและต่างประเทศแล้วนะครับเราก็ยังคิดว่าอีกหนึ่งกิจกรรมดีๆนะครับที่อยากให้นิสิตนักศึกษานะครับให้ความสนใจนะครับก็คือการที่เราได้จัดโครงการแข่งขันว่าความศาลจำลองขึ้นนะครับเพราะว่าเราคิดว่าโครงการเนี่ยนอกจากนักศึกษาจะได้เรียนรู้จากในหนังสือแล้วเราควรที่จะปฏิบัติงานจริงนะครับโดยโครงการครั้งแรกนะครับเราเริ่มจัดตั้งแต่ปี 2542 นะครับโดยในสมัยก่อนเนี่ยเราจัดเฉพาะภาคภาษาอังกฤษนะครับแล้วต่อมาเราก็ได้มีการจัดต่อเนื่องเรื่อยๆนะครับปีเว้นปีนะครับจนครั้งนี้เนี่ยเป็นครั้งที่ 14 แล้วนะครับแล้วก็ได้มีการขยายโอกาสให้กับน้องๆนักศึกษาได้กว้างขึ้นโดยการแข่งภาคภาษาไทยด้วยนะครับเพื่อให้น้องๆในหลายมหาวิทยาลัยทั่วประเทศนะครับได้มีส่วนร่วมในการแข่งขันครับ
โหเรียกได้ว่าน้องๆได้มีโอกาสเข้ามาแข่งขันกันมากขึ้นเลยนะคะค่ะสำหรับขั้นตอนการแข่งขันนะคะกว่าจะผ่านมาถึงวันนี้เนี่ยรอบชิงชนะเลิศเนี่ยมีการเตรียมตัวแล้วก็เตรียมการยังไงบ้างนะคะท่านเลขา
ครับจริงๆโครงการนี้อย่างที่ผมบอกนะครับเราจัดปีเว้นปีแล้วเราก็เตรียมตัวกันมานานนะครับแต่เนื่องจากสถานการณ์โควิดที่ผ่านมานะครับจริงๆครั้งที่14เนี่ยเราจะต้องจัดในปี 2564 นะครับแต่ว่ามีสถานการณ์โควิดที่ทำให้น้องๆในมหาวิทยาลัยเนี่ยบางไม่ได้ไปเข้าเรียนกันที่มหาลัยด้วยซ้ำนะครับเราคิดว่าการจะว่าความออนไลน์เนี่ยมันก็อาจจะไม่ได้ตอบโจทย์ของโครงการที่แท้จริงนะครับเราก็เลยรอจังหวะที่พร้อมนะครับก็เลยเลื่อนมาเป็นการจัดการแข่งขันในปีนี้นะครับ 2566 นะครับซึ่งในรอบการแข่งขันรอบคัดเลือกนะครับด้วยที่ความที่น้องๆเนี่ยตอนช่วงโควิดน้องก็อาจจะได้เรียนออนไลน์กันเยอะนะครับเราก็คิดว่าน้องๆเนี่ยน่าจะรู้จักเทคโนโลยีกันมากขึ้นนะครับรูปแบบรอบคัดเลือกเราก็เปลี่ยนไปนะครับโดยให้น้องๆอัดเป็นคลิปวิดีโอนะครับสั้นๆความยาวประมาณ 5-7 นาทีนะครับโดยเป็นหัวข้อที่ใกล้ตัวน้องๆด้วยนะครับเป็นหัวข้อเกี่ยวกับเทคโนโลยีกับอนาคตของกฎหมายทรัพย์สินทางปัญญานะครับซึ่งเป็นเรื่องเกี่ยวกับเทคโนโลยีดิจิทัลนะครับซึ่งพอน้องๆอัดคลิปมาแล้วเนี่ยเราก็จะเชิญน้องๆทุกทีมนะครับที่ส่งคลิปวิดีโอมาสัมภาษณ์ภาษาไทยที่ทั้งภาษาไทยและภาษาอังกฤษที่ศาลเราด้วยนะครับเพื่อดูทัศนคติของน้องๆว่าในสิ่งที่น้องทำคลิปมาเนี่ยเป็นยังไงบ้างนะครับแล้วจากทีมทั้งหมดนะครับซึ่งเราได้รับการตอบรับที่ดีมากนะครับเราได้ทีมภาษาไทยทั้งหมด23ทีมจาก16มหาวิทยาลัยนะครับและก็ทีมภาษาอังกฤษ11 ทีมจาก 8 มหาวิทยาลัยนะครับจนเราคัดเลือกมาเหลือ 8 ทีมสุดท้ายนะครับในรอบแข่งขันว่าความนะครับซึ่งพอเข้ารอบ 8 ทีมสุดท้ายนะครับเราจะให้แต่ละทีมเนี่ยมาอบรมนะครับในการแข่งขันว่าความเบื้องต้นนะครับโดยให้รุ่นพี่ที่มีประสบการณ์นะครับที่ทั้งเป็นท่านผู้พิพากษาที่อยู่ที่ศาลที่เคยมีประสบการณ์ว่าความที่ศาลแล้วนะเคยตอนเป็นนักศึกษานะครับรวมถึงรุ่นพี่ที่ชนะเลิศหรือรวมถึงทีมรองชนะเลิศเมื่อปีก่อนๆนะครับแล้วไม่ว่าปัจจุบันจะทำงานอยู่สำนักงานกฎหมาย ายอยู่สำนักงานอัยการหรือผู้พิพากษานะครับมาให้ความรู้น้องๆนะครับหลังจากนั้นก็มีการแข่งรอบ8ทีมในเดือนสิงหานะครับรอบ4ทีมจนรอบชิงชนะเลิศในวันนี้ครับก็เรียกได้ว่าฝ่าฟันหลายขั้นตอนมากๆครับ
ค่ะก็น้องๆ8ทีมที่ผ่านเข้ามาได้นี่ถือว่าสุดยอดมากๆเลยนะคะก็สำหรับการแข่งขันรอบชิงชนะเลิศในวันนี้ค่ะอยากจะให้ท่านช่วยวิเคราะห์หน่อยค่ะว่าการแข่งขันในวันนี้เนี่ยเป็นยังไงบ้างนะคะ
ครับก็เรียกได้ว่าอย่างที่บอกนะครับสนุกและตื่นเต้นเป็นอย่างยิ่งนะครับแล้วยิ่งโจทย์การแข่งขันของเราในแต่ละปีนะครับก็จะเป็นที่ให้ความสนใจกับหลายๆหน่วยงานนะครับเพราะว่าโจทย์เนี่ยนอกจากเราจะต้องดีไซน์ให้เข้ากับยุคเข้ากับสมัยที่เปลี่ยนแปลงไปแล้วนะครับไม่ว่าจะเป็นรอบคัดเลือกที่ผมบอกไปว่าเราใช้เรื่องเกี่ยวกับเทคโนโลยีดิจิทัลนะครับรอบ8ทีมหรือรอบ4ทีมสุดท้ายเราออกโจทย์เกี่ยวกับเรื่องลิขสิทธิ์เครื่องหมายการค้าที่เกี่ยวข้องกับสูตรอาหารนะครับซึ่งมันเป็นประเด็นพิพาทกันอยู่ในปัจจุบันนี้นะครับและในโจทย์รอบชิงชนะเลิศเนี่ยเราก็ปรับให้เข้ากับสถานการณ์ที่เกิดขึ้นในช่วง 2-3 ปีที่ผ่านมาก็คือสถานการณ์โควิดนะครับคือในช่วงสถานการณ์ของโจทย์ในรอบชิงนะครับเราจะใช้การเรียนแบบสถานการณ์ที่เกิดขึ้นเมื่อ 2-3 ปีที่ผ่านมานะครับโดยยกตัวอย่างว่าเป็นประเทศสมมุตินะครับที่ชื่อว่าประเทศกาแลนด์นะครับประเทศนี้เนี่ยเกิดการระบาดของเชื้อไวรัสชนิดหนึ่งนะครับเป็นโรคทางเดินหายใจเฉียบพลันหรือที่เรียกว่าโรคเอียสนะครับซึ่งโรคนี้เนี่ยจะรักษาให้หายได้ต้องใช้ยาตัวหนึ่งในการรักษาซึ่งเทคโนโลยีในการผลิตยาชนิดนี้เนี่ยทางประเทศของเขาเองไม่สามารถผลิตได้นะครับเขาก็เลยต้องใช้บริษัทยาบริษัทหนึ่งชื่อบริษัทไซเฟอร์นะครับซึ่งเป็นบริษัทของประเทศอินโซมเนียนะครับแต่ว่าลำพังประเทศกาแลนด์เนี่ยจะซื้อยาเองก็ไม่ได้เพราะว่าต้นทุนในการผลิตยาค่อนข้างสูงนะครับแล้วทางรัฐบาลเนี่ยไม่สามารถจ่ายเงินเพื่อซื้อยาตัวนี้ได้ก็เลยอาศัยข้อกฎหมายนะครับเกี่ยวกับเรื่องสิทธิบัตรก็คือการบังคับใช้สิทธิ์หรือ compulsory licensing นะครับบังคับให้เอาสูตรยาของบริษัทไซเฟอร์นะครับมาขายให้กับมาเปิดเผยให้กับประเทศกาแลนด์นะครับโดยประเทศกาแลนด์เนี่ยจะมีบริษัทผลิตยาที่รัฐบาลเป็นหุ้นส่วนอยู่ผลิตยาราคาถูกนะครับให้กับประชาชนภายในประเทศนะครับซึ่งประเด็นตรงนี้เนี่ยคิดว่าเป็นประเด็นที่น่าสนใจมากนะครับเพราะว่าเป็นการพิพาทกันบริษัทไซเฟอร์เนี่ยเขาก็มองว่าเขาถูกรัฐบาลเอาเปรียบนะครับก็เลยมีการมาฟ้องร้องคดีกันที่ศาลนะครับประเด็นมันน่าสนใจตรงอยู่ที่ว่าเราจะปกป้องเจ้าของสิทธิ์ในสิทธิบัตรยานะครับเจ้าของสิทธิ์ในทางทรัพย์สินทางปัญญาอย่างไรเมื่อเทียบกับผลประโยชน์ของประชาชนภายในประเทศนะครับซึ่งตรงนี้เนี่ยเป็นสิ่งที่เราต้องมาชั่งน้ำหนักกันนะครับว่าระหว่างสิทธิ์ในทางทรัพย์สินทางปัญญากับสิทธิ์ในสุขภาพของประชาชนเนี่ยตรงไหนสำคัญกว่ากันนะครับซึ่งน้องๆทั้งสองทีมก็ต้องโน้มน้าวใจคณะกรรมการนะครับให้เห็นว่าทางฝั่งไหนเนี่ยไม่ว่าจะเป็นเจ้าของสิทธิ์ทางด้านเอกชนนะครับหรือว่ารัฐบาลที่ต้องดูแลประชาชนภายในประเทศสุขภาพของประชาชนเนี่ยตรงไหนสำคัญกับกันนะครับซึ่งคิดว่าน่าจะได้ดูกันแล้วนะครับแล้วน้องๆก็แสดงเหตุผลได้อย่างน่าสนุกตื่นเต้นจริงๆครับ
อ๋อค่ะเรียกได้ว่าโจทย์หินแล้วก็น่าสนใจขนาดนี้อยากรู้แล้วค่ะว่ารางวัลสำหรับประเภททีมที่ชนะเลิศแล้วก็รองชนะเลิศเนี่ยจะได้รับรางวัลอะไรบ้างนะคะ
โหถ้าโจทย์ยากขนาดนี้นะครับรางวัลของเราก็ไม่ธรรมดาอยู่แล้วนะครับก็อย่างที่ทุกท่านได้เห็นนะครับในปีนี้นะครับเราจากทางด้านหลังนะครับเราได้รับพระมหากรุณาธิคุณนะครับจากสมเด็จพระเจ้าลูกเธอเจ้าฟ้าพัชรกิติยาภานเรนทิราเทพยวดีกรมหลวงราชสารินีสิริพัฒน์มหาวชรราชธิดานะครับในการพระราชทานถ้วยรางวัลนะครับแก่ทีมชนะเลิศทั้งภาคภาษาไทยและภาคภาษาอังกฤษนะครับแล้วนอกจากนี้นะครับทีมที่ชนะเลิศและรองชนะเลิศยังได้ทุนการศึกษานะครับรวมถึงทีมที่ผ่านเข้ารอบ8ทีมสุดท้ายด้วยนะครับและเท่านั้นยังไม่พอนะครับทีมชนะเลิศนะครับเรายังมีโอกาสนะครับให้ไปทัศนศึกษานะครับยังต่างประเทศนะครับโดยปีนี้เราได้รับความร่วมมือจากองค์การค้าต่างประเทศของญี่ปุ่นนะครับหรือ JTRO นะครับในการไปทัศนศึกษาที่ประเทศญี่ปุ่นนะครับและทีมรองชนะเลิศได้รับความร่วมมือจากองค์การคุ้มครองลิขสิทธิ์เกาหลีหรือ KCOPA นะครับในการพาน้องๆไปทัศนศึกษาที่ประเทศเกาหลีด้วยยังไม่หมดนะครับ
โอ้โหยังไม่หมดอีกเหรอคะ
เรามีรางวัลมากกว่านี้นะครับเพราะปีนี้เราพิเศษครับเราคิดว่าน้องๆเนี่ยนอกจากผ่านเข้ารอบ4ทีมสุดท้ายนะครับเราจะให้โอกาสน้องๆได้ไปฝึกงานนะครับในlaw firmที่เกี่ยวข้องกับทรัพย์สินทางปัญญาหรือการค้าระหว่างประเทศที่มีชื่อเสียงนะครับและเป็นlaw firmที่ให้ความร่วมมือกับเราได้ดีนะครับไม่ว่าจะเป็น Baker and McKinsey นะครับ Rouse and Co นะครับสัตยพล and Partner นะครับหรือ Tilaki and Gibbin นะครับซึ่งก็จะเป็นประโยชน์กับน้องๆนะครับไม่ใช่จบโครงการแล้วจบเลยนะครับน้องๆก็ได้ประสบการณ์ในระยะยาวด้วยครับ
ค่ะ ก็สำหรับน้องๆที่เข้าร่วมโครงการนี้นอกจากจะได้รับรางวัลแล้วเนี่ยยังได้ประสบการณ์ต่างๆมากมายเลยใช่ไหมคะค่ะอยากให้ท่านเลขาค่ะช่วยฝากถึงน้องๆที่ดูอยู่นะคะว่าสำหรับคนที่สนใจในรุ่นถัดไปเนี่ยจะต้องเตรียมตัวยังไงบ้างอะคะ
ครับก็อย่างที่ผมเรียนไว้แล้วนะครับว่าโครงการของเราเนี่ยจัดทุกปีเว้นปีนะครับถ้าตอนนี้เนี่ยน้องๆดูอยู่น้องๆก็เตรียมตัวได้เลยนะครับไม่ว่าน้องๆจะอยู่ปี1หรือปี2นะครับอีก2ปีนะครับน้องๆก็อยู่ปี3หรือปี4ซึ่งก็เป็นวัยที่บ่มเพาะความรู้พอดีนะครับลงเรียนวิชาทรัพย์สินทางปัญญาหรือการค้าระหว่างประเทศไปเลยนะครับเพราะว่าเป็นวิชาที่เป็นพื้นฐานความรู้กฎหมายซึ่งปัจจุบันนี้มันได้ปรับใช้ในความรู้เป็นอย่างยิ่งนะครับน้องๆก็บ่มเพาะความรู้ไปเลยแล้วก็รอดูประกาศของศาลนะครับว่าอีก2ปีเนี่ยเราจะอากาศเมื่อไหร่นะครับแล้วบางทีเนี่ยเราจะประชาสัมพันธ์หน้าเว็บไซต์นะครับแล้วเราจะส่งจดหมายไปที่มหาวิทยาลัยนั้นๆด้วยนะครับซึ่งจริงๆตอนนี้ผมทราบว่าในหลายๆมหาวิทยาลัยมีชมรมนะครับเกี่ยวกับการแข่งขันมูดคอร์ดกันอยู่แล้วนะครับก็จะได้ประชาสัมพันธ์น้องๆแล้วก็เตรียมตัวกันให้เป็นอย่างดีนะครับแล้วผมอยากฝากบอกว่าจริงๆนะครับประสบการณ์การแข่งขันนะครับมันมากกว่าสิ่งที่น้องเรียนในห้องเรียนอยู่แล้วนะครับโอกาสที่น้องจะได้ถ้าน้องแค่นั่งเรียนอ่านหนังสือสอบก็จบถูกไหมครับแต่โอกาสที่น้องจะได้เข้ามานะครับแล้วมาดูสถานการณ์ในความเป็นจริงว่าหากน้องต่อไปน้องประกอบอาชีพทางด้านกฎหมายนะครับน้องเป็นทนายความน้องจะมีประสบการณ์ยังไงนะครับรวมถึงมีผู้คนมาชมรวมถึงในวันถ่ายทอดสดในวันนี้นะครับซึ่งจริงๆผมเองขนาดเป็นนักศึกษาเนี่ยผมยังทำไม่ได้ขนาดน้องๆนะครับแต่คิดว่าเป็นประสบการณ์ที่มีค่านะครับสำหรับน้องๆนิสิตนักศึกษาทุกคนที่สนใจจริงๆนะครับและคิดว่าน่าจะเป็นประโยชน์ต่อไปในอนาคตและประสบความสำเร็จต่อไปเรื่อยๆครับ
ค่ะแล้วน้องๆที่สนใจนะคะก็อย่าลืมติดตามจากหน้าเว็บศาลทรัพย์สินทางปัญญาและการค้าระหว่างประเทศนะคะเป็นเรื่อยๆนะคะก็ท่านเลยค่ะตอนนี้ดูเหมือนว่าท่านคณะกรรมการของเราเนี่ยจะรวบรวมคะแนนกันเสร็จเรียบร้อยแล้วนะคะเดี๋ยวเราตัดภาพไปที่ห้องพิจารณาคดีกันดีกว่านะคะสำหรับวันนี้นะคะท่านเลยค่ะแล้วก็ดิฉันขอตัวลาไปก่อนนะคะสวัสดีค่ะ
สวัสดีครับ
การแถลงการปิดคดีด้วยวาจารอบชิงชนะเลิศทั้งทีมภาษาไทยและทีมภาษาอังกฤษก็ได้เสร็จสิ้นลงแล้วครับในลำดับต่อไปจะเป็นการประกาศผลการแข่งขันของทีมภาษาไทยระหว่างทีม M-Bot ทนายฝ่ายโจทย์พบกับทีม Y2G ทนายฝ่ายจำเลยขณะนี้ท่านคณะกรรมการทีมภาษาไทยพร้อมแล้วขอเรียนเชิญท่านคณะกรรมการครับ
ครับก็องค์คณะก็ขึ้นมาอีกครั้งนะครับในการนี้มาในฐานะกรรมการผู้ตัดสินต้องบอกว่ากรรมการก็พยายามพูดคุยกันอย่างละเอียดนะครับรอบด้านต้องบอกว่าสูสีนะฮะสูสีกันมากแล้วก็ลำบากในการตัดสินใจพอสมควรเพราะว่าอย่างที่กล่าวถึงในตอนต้นนะครับเรื่องของ CL เนี่ยเป็นเรื่องที่แม้จะมีกฎเกณฑ์ไว้มันก็ค่อนข้างกว้างว่าในหลักการฉะนั้นเนี่ยเป็นเรื่องที่แต่ละประเทศเนี่ยอาจจะมีมาตรฐานการใช้ที่แตกต่างกันนะครับแล้วก็ถามว่าคดีที่ศาลไทยเนี่ยน่าจะไม่เคยมีคำพิพากษาไม่ว่าจะส่วนถึงการใช้มาตรการชอบหรือไม่ชอบหรือเรื่องของค่าตอบแทนนะครับก็ไม่เคยมีคดีนะครับหรือแม้แต่ในต่างประเทศเองก็ตามน่าจะไม่แน่ใจน่าจะไม่ได้หาได้ง่ายๆนะครับดังนั้นก็หลายๆอย่างมันขึ้นกับสถานการณ์ก็อยู่ที่การให้เหตุผลในขณะที่โจทย์คำถามในบางประเด็นก็อาจจะมีเป็นธรรมดาครับโจทย์มูดคอร์ดมีความได้เปรียบเสียเปรียบกันบ้างแต่คณะกรรมการก็พยายามชดเชยเวทน้ำหนักของต่างๆโอกาสความยากง่ายในการต่อสู้ก็ต้องถือว่าชื่นชมนะครับทั้งสองทีมจริงๆเลยนะครับที่รู้เลยว่าพยายามอย่างมากนะครับในการค้นคว้าหาเหตุผลหาก็กฎหมายต่างๆที่มานะครับต้องบอกว่าคณะทำงานที่ทำโจทย์เนี่ยท่านได้พยายามลิสต์ข้อต่อสู้ในทางที่เป็นไปได้นะครับของแต่ละประเด็นของทั้งสองด้านทั้งฝ่ายโจทย์จำเลยเนี่ยทั้งในกฎหมายภายในและก็ความตกลงระหว่างประเทศหรือหลักเกณฑ์ต่างๆมานะครับเราเรียกว่ามาเตรียมรับกับทั้งสองทีมนะครับแต่ว่าท่านก็เหมือนกันนะฝ่ายที่แข่งขันนะก็เห็นได้ว่าท่านก็พยายามหากฎหมายต่างๆนะครับอย่างยกตัวอย่างเนี่ยบอก แต่กรรมการนี่ก็ยังมึนโหเก่งมากเลยไปหาพระราชบัญญัติป้องกันและบรรเทาสาธารณภัย 2550 เนี่ยคณะทำงานก็ไม่เคยเตรียมพระราชบัญญัตินี้มาเลยนะก็ชื่นชมต้องบอกเลยเมื่อกี้ต้องชักมือถือมาเปิดดูพระราชบัญญัตินี้บนบัลลังก์เลยว่าเป็นยังไงไม่เคยเห็นเหมือนไม่เคยดูเนื้อหาเหมือนกันนะครับก็อันอื่นส่วนอื่นๆหรือว่าในเรื่องของความตกลงระหว่างประเทศความตกลง TRIPS Agreement ก็ดีนะฮะหรือว่า Doha Declaration เนี่ยก็อันนี้ก็ไปเป็นความตกลงคงหลักที่จะต้องตามไปดูกันอยู่แล้วนะครับก็ถือว่าก็ทำกันได้ดีนะครับส่วนหลักเกณฑ์นะครับที่กรรมการดูเนี่ยนะครับหลักเกณฑ์ที่คณะทำงานนะได้วางไว้ก็คือดูทั้งเรื่องของการปรับใช้และการให้เหตุผลทางกฎหมายในการสนับสนุนนะข้ออ้างนะข้อต่อสู้นะครับความรู้ความเข้าใจกฎหมายทฤษฎีแนวคิดและพื้นฐานกฎหมายนะครับก็อย่างที่ตรงนี้ก็เป็นส่วนที่ได้ถามนอกเหนือจากนั้นนะครับว่าเพราะว่าการที่ถ้าฟังอย่างเดียวเนี่ยฟังที่เตรียมมาเนี่ยก็ยากที่จะวัดว่าจริงๆนะเข้าใจเรื่องนั้นๆแค่ไหนก็ลองถามดูบ้างนะครับว่าเป็นสิ่งที่อาจจะอยู่นอกเหนือจากโจทย์ตรงๆนะก็ต้องถือว่าชื่นชมเช่นกันก็ทำได้ดีนะครับนะก็เรามาดูถึงความคล่องแคล่วตรงนี้ที่ว่าเป็นความคล่องแคล่วและความสามารถในการนำเสนอและการตอบคำถามนะครับก็พิจารณาแล้วก็สุดท้ายที่เป็นตัวย่อยที่สุดนะครับก็ไม่ได้มีการแตกต่างอุปนิสัยทัศนคติบุคลิกภาพการแต่งกายการจัดการและการบริหารเวลาก็ทำได้ต้องเรียกว่าข้อหลังแต่ว่าคะแนนก็น้อยหน่อยก็คือไม่ได้แตกต่างอะไรกันมากนะครับนะแต่ก็เมื่อดูแล้วนะครับพิจารณากันแล้วนะครับคุยกันระหว่างกรรมการ5 คนรวมทั้งท่านคณะทำงานที่ท่านเป็นเจ้าของข้อสอบและท่านก็ได้นั่งฟังแล้วก็มาช่วยให้ความเห็นนะครับนะสุดท้ายก็ต้องมีนะครับชนะเลิศและรองชนะเลิศนะอยู่ดีนะครับก็กรรมการพิจารณาแล้วก็มีความเห็นร่วมกันนะครับให้ทีมที่ชนะเลิศนะครับคือทีม MBOT นะครับของฝ่ายโจทย์นะแล้วก็รองชนะเลิศก็คือ Y2G นะครับก็ต้องชื่นชมทั้ง2ท่านก็มันต้องตัดสินนะครับนะแต่ว่าชื่นชมว่าเก่งทั้ง2ทีมเลยนะครับท่านก็ได้รางวัลก็มีคนมากระซิบว่าจริงๆทีมรองชนะเลิศนะอาจจะถูกใจในรางวัลที่ได้รับก็ได้มีคนแอบมากระซิบนะแต่จริงๆตัดสินไม่ได้คำนึงถึงสิ่งนี้นะครับว่าก็ตัดสินไปตามเนื้อหาทุกด้านอย่างที่ได้กล่าวไปแล้วนะครับก็ขอแสดงความยินดีทั้ง2ทีมด้วยนะครับนะก็คือในส่วนของการแข่งขันมูดคอร์ดนะครับหรือการว่าความในศาลจำลองในส่วนภาคภาษาไทยก็เสร็จสิ้นลงเพียงเท่านี้นะครับ
ครับขอบพระคุณท่านคณะกรรมการทุกท่านครับและขอแสดงความยินดีกับทีม MBOT นะครับประกอบด้วยนางสาวสุชานันท์ลุกขจันทรกุลและนางสาวเบญญาดาบุญเสริมสุวงศ์จากมหาวิทยาลัยธรรมศาสตร์ที่ได้รับรางวัลชนะเลิศครับและทีม Y2G ประกอบด้วยนางสาววีรดาวิระยะวงศ์และนางสาวสุภานีจันทดวงจากมหาวิทยาลัยนเรศวรที่ได้รับรางวัลรองชนะเลิศครับลำดับต่อไปจะเป็นการประกาศผลการแข่งขันของทีมภาษาอังกฤษระหว่างทีมออนนี่และผู้ติดตามทนายฝ่ายโจทย์พบกับทีม Undertake ทนายฝ่ายจำเลยขณะนี้ท่านคณะกรรมการทีมภาษาอังกฤษพร้อมแล้วขอเรียนเชิญท่านคณะกรรมการครับ
So this is the announcement. Maybe the good news is that there are no losers. There are only winners. Every team, every law school that are represented in this competition are winners, and the most important winners is Thailand, law schools in Thailand, which have produced a new crop of young lawyers of this competence, and all law professors in all law schools are to be congratulated to have produced such a new crop of generations of young lawyers that we are very, very proud of. Now, you sort of struggle of the standard of proof. Well, I have to announce that the teams that will eventually have the peerage of Her Royal Highness Princess Trophy wins on not on the basis of beyond reasonable doubt. No, not beyond reasonable doubt. Not even you could produce clear and convincing evidence that you win. No, not clear and convincing, but only on balance of probabilities, just a bit, tiny bit of, and we sort of have to accept that the problem somehow, just like life maybe is unfair sometimes, or sometimes this is most of the times. You get to represent a client which you need to work magic in order to. But anyway, you have represented the best arguments that your client, the recently elected Prime Minister, who is so keen on his agenda, a political agenda, that he is very, very ably represented by this young team of public prosecutors, but yet we feel that justice must prevail when the Prime Minister order and the order to disclose the trade secret must be set aside. So we give on balance of probabilities, we feel that the plaintiffs are a little bit, yeah. So congratulations to you to become the second best. All right, and congratulations. And well, this may bring an end to this very exciting competition, moot court competition. We hope, as judges, hope that we will only help to encourage law schools to produce lawyers in the legal profession who could work on par with our colleagues from National University of Singapore, Malaya, University of Philippines, Hanoi, and elsewhere in the world, to be representing your clients in all the important venues in the world: London, New York, Hong Kong, Singapore, and why not Bangkok. So thank you very much for this very, very happy time that we spent together. I hope all the best. We hope all the best for your future. Thank you. Thank you very much.
ครับขอบคุณท่านคณะกรรมการทุกท่านครับและขอแสดงความยินดีกับทีมออนนี่และผู้ติดตามประกอบด้วยนายรณวิทย์ลิมปานุกรและนางสาวพันธิราดอนสกุลจากมหาวิทยาลัยธรรมศาสตร์ที่ได้รับรางวัลชนะเลิศครับและทีมอันเดอร์เทคประกอบด้วยนางสาวพิชยดาอมรรัตนะและนางสาวนภัชชาจัสกุล่าจากจุฬาลงกรณ์มหาวิทยาลัยที่รับรางวัลรองชนะเลิศครับ ครับก็เสร็จสิ้นไปเป็นที่เรียบร้อยแล้วนะครับสำหรับการแข่งขันแถลงการปิดคดีด้วยวาจารอบชิงชนะเลิศภายใต้โครงการแข่งขันว่าความในศาลจำลองประจำปี 2566 CIPITC Moot Court Competition 2023 ครับขอแสดงความยินดีอีกครั้งหนึ่งกับทีมผู้ชนะเลิศทั้ง2ทีมครับสำหรับทีมภาษาไทยได้แก่ทีม M-Bot จากมหาวิทยาลัยธรรมศาสตร์และทีมภาษาอังกฤษได้แก่ทีมออนนี่และผู้ติดตามจากมหาวิทยาลัยธรรมศาสตร์ขอเสียงปรบมือให้กับน้องๆผู้เข้าแข่งขันทั้ง2ทีมอีกครั้งหนึ่งครับครับขอบคุณครับทั้งนี้จะมีพิธีรับถ้วยรางวัลพระราชทานจากสมเด็จพระเจ้าลูกเธอเจ้าฟ้าพัชรกิติยาภานเรนทิราเทพพยวดีกรมหลวงราชสารินีสิริพัฒน์มหาวชรราชธิดาในวันพฤหัสบดีที่ 21 กันยายน 2566 และพิธีมอบรางวัลสำหรับทีมที่ผ่านเข้ารอบ 8 ทีมสุดท้ายในวันเดียวกันด้วยครับในนามของศาลทรัพย์สินทางปัญญาและการค้าระหว่างประเทศกลางขอขอบพระคุณแขกผู้มีเกียรติทุกท่านที่เสียสละเวลาร่วมเป็นสักขีพยานและร่วมเป็นกำลังใจให้กับน้องๆผู้เข้าแข่งขันในครั้งนี้และที่สำคัญโครงการนี้สำเร็จลุล่วงไปได้ขอขอบพระคุณผู้ร่วมจัดโครงการชมรมผู้พิพากษาสมทบในศาลทรัพย์สินทางปัญญาและการค้าระหว่างประเทศกลางกรมทรัพย์สินทางปัญญากระทรวงพาณิชย์องค์การส่งเสริมการค้าต่างประเทศของญี่ปุ่นเจโทกรุงเทพองค์การคุ้มครองลิขสิทธิ์แห่งสาธารณรัฐเกาหลีบริษัททูคอร์ปอเรชั่นจำกัดมหาชนครับ
และได้รับการสนับสนุนจากบริษัทเบอร์รี่ยูเกอร์จำกัดมหาชนและบิ๊กซีซูเปอร์เซ็นเตอร์จำกัดมหาชนบริษัทเครือเจริญโภคภัณฑ์จำกัดบริษัททริปเปิลทีบรอดแบนด์จำกัดมหาชนบริษัทโมโนเน็กซ์จำกัดมหาชนบริษัทแสนสิริจำกัดมหาชนบริษัทสุนทรเมทัลอินดัสทรีจำกัดบริษัทวอริกสปอร์ตจำกัดมหาชนและหน่วยงานอื่นๆที่ให้การสนับสนุนสำนักงานกฎหมายที่ให้ความอนุเคราะห์การฝึกงานบริษัทเบเกอร์แอนด์แมคเคนซี่จำกัดบริษัท Rouse & Co International ประเทศไทยจำกัดบริษัทสัตยพลแอนด์พาร์ทเนอร์จำกัดบริษัทติลิกี้แอนด์กิฟบินส์อินเตอร์เนชั่นแนลจำกัดขอบพระคุณแขกผู้มีเกียรติทุกท่านอีกครั้งนะคะรวมไปถึงท่านผู้ชมที่รับชมการถ่ายทอดสดผ่านทางช่อง TNN2 สำหรับวันนี้ช่วงเวลาของการถ่ายทอดสดเสร็จสิ้นลงแล้วขอบพระคุณค่ะสวัสดีค่ะ